Namaste.
You
Namaste,
are not
President sir.
audible.
Namaste, President sir.
Namaste.
Namaste. Today we will begin second day of FLG conference. So first of all, I would like to introduce with our guest, Professor Renu Jatana, ex-Dean and Faculty Chairman, UCCC MS Sukhadia University, Udaipur, keynote speaker and session chair. And our second guest, Dr. Naptika Singh Nautiyal, Assistant Professor at National Forensic Science University, Gandhinagar, Gujarat, keynote speaker and session chair. Thank you both of you, sir, ma'am, coming and acknowledge our students and with your valuable knowledge. Now, over to you, Tanushri ma'am. Please start. Tanushri ma'am, please continue the session. So, Naptika Singh Nautiyal ma'am, please share your knowledge on the topic of national conference.
Thank you so much, ma'am, for inviting me. And Namaste, President Sir.
Namaste.
It's a wonderful morning, and thank you for giving me the topic ADR in family dispute. So, if you allow me, I can share my screen and can start the presentation.
Yes, please do that.
Please,
It will
thank you
be
so much,
good
sir.
for all the delegates and the listeners and who are associated with us to hear you. Please.
Yes, sir. Thank you so much, sir. I have to upload the file first. Give me just a second,
Yes.
please. Sorry for this interruption. I am also new to this platform. Yeah, it is uploaded. So, ADR in family dispute. When I got this topic, I remember my internship days when I was an intern in law field, and I used to see the family dispute matter. People are coming for their divorce. People are coming for their matrimonial issues under 498A of IPC. Uh, you know, there was a question in my mind which has been resolved in my master's days. The question was, there are two people in house. They're sharing their bond, they're sharing their happy moment, even their their sadness, their sorrows together. What is that breaking point where they both are coming to the edge that they have to come to the court? The question was there, and I asked this question to one of my faculty in my LLM days in Indian Law Institute. He answered that, Naftika, there is a four wall theory. What is this four wall theory, friends? I want to begin that four wall theory, and then we can understand this ADR in family dispute. The four wall says that a house has a sanctity, a house has a privacy. No one can enter because it is within the four wall of a family. So if the house wants to go out, or the people of the house wants to go out, they have to cross a boundary. So when they're crossing the boundary, they are not only taking their dispute, they're not only taking their issue, they're also taking their privacy out of their premises. So if it is able to solve their dispute with any other mechanism, this is the this is the solution to solve the dispute. Because in this modern world we can see that what is the divorce ratio. Yes, it is increasing day by day, friends. The second problem is that the common factor of understanding is very less. So if there will be arbitration, and if the arbitrator will play a significant role, I think this is a solution, and this can be the light of day. So with this, I want to go ahead, and I think my slides are also visible. So friends, what is the introduction? The introduction of my presentation is that in the spirit of, not in the form of law, but to keep the justice alive, by the words of L.J. Earl Warren, I want to say it to you all, that it is this, to keep the justice alive, we have to see this conflict, family dispute within the four walls. Conflict management nowadays, there are counselors, there are psychologists for conflict management. So the before going to the court, let's talk to that counselor, let's talk to the person who can provide the solution. The third important thing is there are two parties who are not commonly in dispute. They are the family members. So if you are taking your family to the court, imagine it's not only your reputation, it's also their reputation which is at the stake. So, with this introduction, let's understand what is ADR. I'm sure this wonderful conference has had the, till now the proper definition and understanding with ADR. Let me just take you to the benefit of this ADR. It says that it reduces hostility. The second one is it's regain a sense of control. See friends, in court you are stating your arguments and you are leaving the justice in hand of the judge. But in mechanism of ADR, you yourself is negotiating on your dispute. So it is wonderful idea, you have a sense of control in ADR. The third one is it's gain and acceptance of the outcome, because when two parties are fighting and they are having a common consensus, that means they can accept the outcome. Yes, it's resolved the conflict in peaceful manner. As we know that it's family, so let's have a peaceful solution. So ADR can only provide this. uh, ADR has these forms. I'm not going into detail because it is well versed. Uh, what are the provisions of ADR under CPC? You all must have had it also. Now this is the topic, and I'll take 5 minutes to conclude and to give a glance of it. ADR in family dispute says that no family dispute can be resolved. Either it will end, or it will be reconciled for time being. But if you are going to alternative dispute resolution, it may be possible that the family dispute will come to a end, will come to a point where you can start your family again. Otherwise, friends, in traditional crime, what happened is, in traditional crimes, victim and accused, they come to a solution and then they move on. But it is not like that in family dispute. In family dispute, both of the people has to live again in under the roof, or they have to end their relationship. So in Husainara Khatun versus Home Secretary of State of Bihar, this was wonderfully stated that right to life and personal liberty and right to speedy trial, with respect to your family dispute, is also important, because there may be kids who are part of this dispute. So you have to even see the future, how many days they will be no one's child. So ADR is a proper solution for that. These are few sections: section 14, section 23 clause 2, proviso of section 13(1), which are talking about the reconciliation under Hindu Marriage Act, which says that before going to the divorce, let's go to the mediation, and let's see that there was a quote, and I want to quote here: before ending a relationship, the relationship is on the ventilator for a long time. So when your relationship is on ventilator, try to reconcile that relationship. So if the person or the relationship can come back out of that trauma, it's a wonderful solution. Because you and or divorce is not a solution. So that's why nowadays court is having this approach that you first go to mediation if you are having kind of conflict or lack of communication or miscommunication. Then please try to talk and resolve it. So these are reconciliation sections. These are to another. Then this is under Special Marriage Act. We also required the reconciliation under Special Marriage Act. So these are few sections, friend. You can refer these section under Special Marriage Act, which talks about that before passing a decree, the court can see that whether the parties can be come to a conclusion or a solution or not, or even speedy trial. This particular section talks about. uh, then there are these sections where matters to which reconciliation does not apply. We also know that if there is under section 13 of Hindu Marriage Act, change of religion, unsoundness, leprosy, vulnerable disease, renunciation of the world, and presumption of death, under this the reconciliation does not apply. Then when a petition of divorce is before the court, what court has to see that if there are there are these five clauses, then there shall not be reconciliation efforts. Why, friends? Because they themselves are so exclusive, so relevant, that now let's not go to arbitration. So keep these clauses in mind. Then we have clauses under Family Courts Act of 1984 too, which talks about that court has to make efforts for settlement. It's a fundamental duty of the court, the family court exclusively, not to end up that relationship, but to give some benefit of doubt, and to provide some solution. uh, this is one case which I want to discuss. It is Bini versus KV Sundaram 2008 case, friends. This says that, and this is a question, that whether conciliation is mandatory after the introduction of Family Courts 1984 or not. Imagine, this is a question in 2008 court is asking, and where it has been held that family court is a special statute, and held no endeavor for reconciliation need to be made in a petition for divorce on a ground of conversion to another religion, or another other grounds accepted. So this is now a fundamental principle, that if there are provisions which I've just explained it to you, if there no need to come to reconciliation. However, it is mandatory, but we'll know that in law there are provisos, and this is another proviso and exception. This is another case, friends, Baljinder Kaur versus Hardeep Singh, where court has emphasized that stress has to given always to preserve the institution of marriage. It's not like that the people have come for divorce and you have granted the divorce. There could be a mediation, there could be a conciliation. Imagine in 1998 court has emphasized, and we are talking it today. This is a conclusion of my presentation, friends. This, yes, let's have ADR, the light of the day. It is an unsung song. Let's emphasize on it, and let's accept this as a real time, because it will provide the speedy trial, and it will be it will be solving the issue, which is because nowadays divorce rate is increasing, family dispute is increasing. So before going to the real time court, because court will come to a conclusion, let's go to the arbitration, and it may be possible your relationship will be a happy relationship. With this, if there will be any doubt, I'm happy to answer also. Lastly, thank you so much once again, ma'am, for giving me this wonderful opportunity to present before the
Uh,
house. Thank you so
uh,
much.
Dr. Naftika, I
Yes,
think
ma'am.
you mean to say we should make arbitration process compulsory before the going in the court in family dispute matters. नक्की कब है? आई थिंक कि वो जा चुकी हैं. Okay, Tanuji ma'am, please continue the session.
Yes, start the session, get the presentation start. One
Yes,
more,
sir.
speaker was supposed to join, Professor Tinu Chatana. So what happened? Some technical issue is there, or what is going on? Or would she be joining us?
Veena ma'am, would she be joining us?
Professor Renu Chatana?
Renu Chatana ma'am, I think
She's not here.
please contact
Okay.
Renu Chatana ma'am.
All right. Start the presentations then.
Okay, sir.
Stuti Narula Markan, are you ready for your presentation? Stuti Narula.
Also, Beena madam, tell the student that a best presenter will be selected. The presentation which happened yesterday and from today's presenters.
Sure,
So
sir.
the student should present, wisely and efficiently, so that they may also get a chance to win this best presenter award.
Yes.
So float this information among the students. And I am also telling here and all the students who are listening, we were going to choose a best presenter from yesterday's presentations and today's presentation of both the sessions. That's all.
So, Miss Stuti, are you ready for your presentation? Stuti, am I audible to you? Kindly unmute yourself and then present.
Ma'am, am I audible?
Yeah, you are audible.
Yeah, wait a
Okay,
minute,
ma'am, please
Tanushi
just give me
madam.
1 minute. I'll
Will
just share
also
my
hear.
screen.
Sanjay sir, are you listening me?
Stuti, just a second.
Yes, Stuti, थोड़ी देर बाद
Yes,
देना तुम अपनी
Abra sir.
presentation. मेरे को
Excuse
थोड़ा
me.
नक्की थोड़ी देर बाद.
So I want to say one thing, that when these students, naturally Dr. Navtika Singh Notial is, with us. Students are presenting the papers, so all papers are to be moderated. Kindly ask the questions from the student, no matter one question. All right. That's all.
Sure,
all
sir. Sure,
I would,
sure, sir.
I added. Thank you.
डॉक्टर नवतिका मैम.
Yes, ma'am.
हाँ, मुझे तो आपसे ऐसे ही बात करना था. जब आपने इतना बोला, तो आपके हिसाब से डू थिंक कि एक arbitration process compulsory before going to the court in family dispute matter?
Ma'am, if it is a divorce matter, I think it can be a solution. But if it is domestic violence, then I think arbitration can be after a reconciliation between a party.
Okay.
So, because for divorce we can use arbitration as a first methodology, but for domestic violence, or even for guardianship, we can go for arbitration as a first alternate. But for domestic violence, exclusively court is only the solution.
अब इसको जरा बताइए मैम कि डोमेस्टिक वायलेंस में ऐसा क्यों नहीं है?
Ma'am, because somebody has unmuted himself or herself. Yeah, ma'am, what I presume, because I am a student of criminal law, in domestic violence, if a person is filing a complaint, that means there is a physical, psychological, and emotional violence, and that the person is suffering. The suffering could be an injury or harm or hurt. So the conciliation, or the person may not be able to talk right now. So the court, because the person needs a remedy now, so court is the solution where they can come to a mutual point and then they can start talking. Because domestic violence, yes, there is some problem, there is a violence included. So for violence, if a person is doing violence, either a man or a woman, I'm not saying only a man do violence. So if there is a violence in a relationship, then there has to be an interference, and the interference has to be from criminal justice system. So this is the idea that for domestic violence, at least there has to be a strong authority which can give a proper order.
मतलब आपका कहना है नक्तिका मैम कि यू मीन टू से कि कॉन्सिलेशन इज बेटर प्रोसेस एज कंपेयर टू आर्बिट्रेशन इन डोमेस्टिक
No,
वायलेंस.
no ma'am, we have to see that conciliation comes in divorce matters, but arbitration comes in, for example, if it is a matter of maintenance, then arbitration, because the arbitrator will be taking both the point of view and then coming to a conclusion. So we have to see the nature of a dispute, and then we have to find a solution. At times, if it is a guardianship, then negotiation can be a solution, because they are negotiating. Okay, you will keep for 1 month, then the child, or I'll be keeping the temporary you know guardianship, and then you can take the permanent. So you have to see, as per the dispute we can decide that which kind of mechanism the relationship can have. Thank you so much.
Our next presenter, Miss Stuti Narula. Stuti, continue your presentation.
Good morning, everybody. Am I audible, ma'am?
You are not audible.
Ma'am, am I audible? Okay. And ma'am, is my screen visible?
Miss Tuti, please kindly be loud. You are not audible.
Okay. Okay. As if I start my presentation, the topic of my presentation is alternative dispute resolution with special reference to international commercial arbitration. So, if I introduce, the Indian legal system is one of the oldest legal system of the world, and the legal system of our country has many fundamental aspects. And this ADR is a part of the judicial system of our country. And in India, we can see that this thing saves times and efforts also. So, if I talk about what is exactly alternative dispute resolution, it means a resolution through an intervention of a third person. In India, the alternative dispute resolution process originated from the panchayat system, which was and is still very prevalent. The Arbitration and Conciliation Act 1996 was prepared to meet the new challenges of modern developing economy of the country. The new techniques such as mediation, negotiation, conciliation were also given the recognition. So when I talk about types of ADRs, as you can see, it's negotiation, mediation, conciliation, evaluation, dispute review court, claims appeal committee, arbitration tribunal, and hybrid also ADR. So if I explain what is negotiation, so when I talk about negotiation, what happens is like two people negotiate in this process. There is no intervention of any kind of third person. They both decide what the conclusion they want, or what result or what solution they want. They negotiate and get into it. Mediation. When I talk about mediation, it simply means that there are two parties, but there is one mediator involved, that is a third person, to solve the problem or give a resolution to the problem. Conciliation. In a conciliation also, there is a third person. He is called a conciliator. Now the difference between mediation and conciliation is that in mediation, the parties, the mediator takes care of the process, but the parties decide what they exactly want, so that they can come to a conclusion. But in conciliation, the conciliator gives them a resolution, and so they follow it. Evaluation. When it comes to evaluation, the parties evaluate the root cause of the problem. They can involve the third person, or they cannot involve the third person as they wish, and they come to a root cause of the problem, so that they can decide what they want to do. Now, dispute review board. Dispute review board is, for example, if there are two parties. So what they'll do is, in the beginning only, they'll make a dispute review board with with another party, or being it a third party, so that in case in future they come to any such kind of problem, so it can be sorted out with this dispute review board. Now, claims appellate committee. When you talk about claims appellate committee, this is something when two parties, they make this claims appellate committee, but only with the seniors of their own parties or their own companies. For example, there are two companies, and managerial at the level of managerial part, they have some problems. So this claims appellate committee would be constituted of those seniors, so that they can sort out this problem. Arbitration Tribunal. Arbitration Tribunal is a body which gives the decision, and that is binding on both the parties. And this hybrid alternative dispute resolution is when two kind of ADR processes are involved in one solution. For example, there is a case and the court says that this party I refer to the ADR, the alternative dispute resolution, maybe mediation or conciliation. So that will be hybrid because there are two processes involved in it. Now, coming to the topic, international perspective on alternative dispute resolution. Now, ADR, as we know, helps to reduce the cost and time and efforts, and it is also a judicial process. It can also help. Similarly, it can help in the trade economy of international, all the countries and the international trade that is involved. The objective of the same is to comprehensively cover international and commercial arbitration, to make provision for arbitral procedure which is fair, efficient, and capable of meeting the needs of the specific arbitration, to provide that arbitral tribunal gives reason for its arbitral award, to ensure that arbitral tribunal remains within the limits of its jurisdictions, to minimize the supervisory role of the arbitral process, to permit an arbitral tribunal to use mediation and conciliation or any other procedures, to provide that every final arbitral award is enforced in the same manner as it was a decree of the court, to provide that settlement agreement reached by the parties as a result of conciliation proceedings
I guess there is some technical issue. Ma'am, should we wait for her or present with our content? Ma'am, should we start?
Yeah.
Okay, okay. So now I would like to invite Jyoti Mishra to present her paper.
Jyoti, you are not audible.
Yes, ma'am, she is just saying. She was just opening her PPT. Ma'am, is she audible now?
No.
No, just a second.
Namaste, who are present in this conference. Honorable Pro-President.
Now is she audible?
Yes.
Okay.
Pro-President, Honorable Pro-President, sir.
Again, she is not audible. She is not audible. I think some technical issue.
Good morning, all of you. Honorable Pro-President, sir, Proctor, sir, Director, ma'am, my coordinator, ma'am, all my colleagues. Firstly, I would like to introduce myself. My name is Jyoti Mishra, pursuing BA LLB 8th SEM. My topic is role of alternative dispute resolution in family dispute. Firstly, here I int- here I discuss about alternative dispute resolution. It is the method of resolving disputes without litigation. It is less consuming time, and it has four types to solve the disputes amongst the parties. Before this, I would like to um, discuss about family disputes. What do you mean by family disputes? Family disputes are a very common type of disputes. It deals with adoption, divorce, succession, guardianship, marriage, and there are four types of ADR. Firstly, negotiation, mediation, arbitration, conciliation. Negotiation is the preeminent mode of dispute resolution. While the two most known forms of ADR are arbitration and mediation, negotiation is the most always attempted first to resolve a dispute. Mediation Mediation is a negotiation carried out with the assistance of a third party. The mediator, in contrast to the arbitrator or a judge, has no power to impose a solution on the parties. The mediator merely aids in the resolution of the dispute by guiding the parties. Next one is arbitration and conciliation. Uh, Arbitration is a flexible and cost-effective alternative to legislation. A party going to arbitration should seek legal advice to help them navigate the system. Conciliation is an ADR process where an independent third party, the conciliator, helps people in a dispute to identify the disputed issues, develop options, consider alternatives, and try to reach an agreement. Here we discuss about advantages of ADR. Some advantages of ADR are like it is flexible, cost efficient, time effective, and give the parties more control over the process and the results. Role of ADR. The main purpose of this ADR in India, like to provide an internal process to increase faculty and staff option in addressing their health science center related disputes and to further the voluntary resolution of problems at the earliest opportunity. Here are some supporting laws like Section 89 in CPC, settlement of disputes outside the court. Here we talk about the 4 types of ADR, which is in legal terms in CPC, Code of Civil Procedure. These are arbitration, conciliation, lok adalat, mediation. Lastly, I would like to conclude my topic. In conclusion, here I say that ADR plays a vital role in our country, like to resolve the disputes very fastly, and as we can say, very cost effectively. So everyone can join to solve their problems. It is very helpful in India. Thank you.
Okay. Jyoti,
Okay.
you tell me, as a लाइव स्टूडेंट अभी भी बहुत अवेयरनेस की कमी है. एज ए लाइव स्टूडेंट आपका क्या रोल होगा इस अवेयरनेस को बढ़ाने के लिए कि लोग अपने फैमिली डिस्प्यूट को पहले कोर्ट में जाने से पहले आउट ऑफ द कोर्ट ही सेटलमेंट करें? व्हाट इज योर रोल?
Veena ma'am, please repeat the question. You are not audible.
ज्योति,
Yes,
am
ma'am.
I audible ज्योति?
Yes, ma'am.
मेरा क्वेश्चन तुमसे ये है ज्योति, एज ए लाइव स्टूडेंट आपका क्या रोल है इन अवेयरनेस, ये जो मीडिएशन सेंटर्स हैं, आर्बिट्रेशन प्लेटफॉर्म्स हैं, इन तक इनकी अवेयरनेस को बढ़ाने के लिए? बिकॉज फाइलिंग द केस इन कोर्ट, लोग क्या करें, पहले इस पे क्यों नहीं जाते लोग? अभी भी अवेयरनेस की कमी है. व्हाट इज योर रोल?
मैम, हम एज ए लॉ स्टूडेंट लोगों को अवेयर करेंगे कि एडीआर एक सिस्टम है जहाँ पे हम लोग मतलब कोर्ट में जाते हैं, लिटिगेशन लगता है, वहाँ पे जाने के बाद फिर टाइमिंग ज़्यादा लगती है, फिर पैसे, फिर मैम लीगल एड भी है, आर्टिकल 39A के अंदर लीगल एड प्रोवाइड करते हैं, लेकिन मैम ये कहना है ना कि टाइम लेस टाइम लगता है वहाँ पे, फिर कॉस्ट भी कम लगता है, फिर उसके बाद जो डिस्प्यूटेड पार्टी होती है वो मतलब उन लोग को डिसीजन जजमेंट नहीं देते हैं एडीआर, एक मतलब उन लोग को एक रास्ता दिखा देते हैं कि मतलब ये ऑब्जर्वेशंस हैं हमारी, तुम यहाँ पे इसको अपने पास ऑब्जर्व करो, या तुम्हारे ऊपर होता है, पार्टीज के ऊपर होता है ये. तो बेसिकली हम तो अवेयर करेंगे एज ए लॉ स्टूडेंट कि यहाँ पे आप जा सकते हो.
कॉस्ट बेनिफिट्स, टाइम बेनिफिट्स, इन सब के लिए ये प्लेटफॉर्म पर तुम्हारा क्या रोल होगा? या ये तो बेनिफिट्स हैं, बट ये अभी भी लोग इसके लिए अवेयर नहीं है. व्हाट इज योर रोल? कैसे अवेयरनेस को बढ़ाएं?
मैम अवेयर करेंगे, लोगों को अवेयर करना हमारा, अवेयर करके हम लोग बताना है, हम लोग को ये चीज़ प्रोवाइड करानी है कि है हमारे यहाँ ये चीज़, लीगल एड भी प्रोवाइड होती है, बट अगर आप एडीआर में जाते हो तो आप लोग सही तरीके से जैसा आप लोग को लगता है आप वैसा मतलब ले सकते हो, उन लोग से ऑब्जर्वेशन ले सकते हो. अब जैसे नॉर्मली लोग कोर्ट्स में जाते हैं तो वहाँ जजमेंट हो जाता है, डायरेक्ट ऑर्डर पास हो जाता है या डिक्री पास होती है, तो हम यहाँ पे हम लोग ऑब्जर्वेशन लेते हैं कि थर्ड पार्टी क्या सोच रहा है, उसका थिंकिंग क्या है हमारे केस को लेके.
मतलब कम्युनिटी डेवलपमेंट एक्टिविटीज को इंक्रीज करोगे?
यस,
राइट. ओके.
If it is allowed, yeah, if it is allowed, can I ask a question to her?
Sure, ma'am. Sure, ma'am.
Thank you. It's a good presentation. Many congratulations. Uh, Dear, I have a question in a form of clarification, as ma'am has rightly asked that what would be our role being law felicitator. Uh, but don't you think so? This is our social responsibility, however. But don't you think so that if matrimonial cases will go to ADR mechanism, uh, there will be less of professional opportunity for advocates. So somewhere or the other, if we'll tell them that okay, you don't go to the regular courts but go to the alternate dispute mechanism where the role of advocate is zero. So don't you think so, somewhere or the other we are creating a full stop on our professional growth?
मैम हेयर आर सम टाइप्स जो मैंने बताए 4 टाइप्स हैं मैम उसमें कुछ ऐसे होते हैं जो जजेस भी रहते हैं वहाँ पे जैसे जो आर्बिट्रेशन या मीडिएटर होते हैं जो कंसिलिएशन में मैम लोकसभा होते हैं मैम वहाँ पे कुछ लॉयर्स भी होते हैं जैसे थर्ड पार्टी जो होती है वो लॉयर होती है या एडवोकेट होते हैं किसी कोर्ट के तो मैम वो ऑब्जर्व करके हमें बताते हैं कि क्या मैम ऐसा फुल स्टॉप तो नहीं लग रहा लेकिन जैसे
बट
पुअर
कम तो हो
पीपल
रहा है, बट
मैम
कम तो हो रहा है ना।
जैसे पुअर पीपल है तो मैम पुअर पीपल के लिए इतना नहीं पॉसिबल हो पाता है कि वो लोग केस इतना चलाएं क्योंकि मैम इतने टाइमिंग्स हो जाते हैं प्रोसीडिंग्स रखे रहते हैं
But
कोर्ट में
for that, dear, we have legal service authorities. For poor people, we have established mechanism of legal service authorities. वो हर लेवल पे है, डिस्ट्रिक्ट से लेके सुप्रीम कोर्ट तक. Okay, no problem. Thank you for the
नहीं
attempt.
मैम आई वुड लाइक टू
हाँ,
आंसर मैम प्लीज
please,
मैम
please.
ये कहना चाह रहे हैं कि हम लोग को जस्टिस भी चाहिए होता है अब जैसे जो चीज हम लोग कोर्ट में एविडेंस के तौर पे डालते हैं मैम उसी चीज पे वो लोग जजमेंट देते हैं अपना नॉर्मली अगर हम लोग एक वाइडर सेंस में अगर बोले तो मैम ऐसा हम लोग इसमें बोल सकते हैं कि हम लोग इसमें ना दो पार्टीज के सुनेंगे भी क्या प्रोसीडिंग्स उसको देख भी रहे हैं कुछ बेसिस पे वो लोग डिसीजन लेते हैं अब हमने नॉर्मली कुछ भी अब मैम कई केसेस ऐसे होते हैं लॉ स्टूडेंट्स केसेस जैसे कि लड़की कई बार झूठे केसेस डाल देती है अपने हस्बैंड्स पे या अपने किसी भी मेल फ्रेंड्स किसी पे भी झूठे मतलब डाल देती है एलिगेशंस तो मैम उसको प्रूव करते करते बर्डन ऑफ प्रूफ लड़के पे होता है तो मैम कई बार ऐसा होता है ना कि जजमेंट उसके फेवर में नहीं आ पाता है तो इधर हम लोग एक हेल्प ले सकते हैं कि भाई तुम क्या एब्जॉर्व कर रहे हो तुम्हारी क्या ऑब्जर्वेशन है तुम क्या देख रहे हो इधर हम लोग को समझा दो कुछ समथिंग लाइक दैट
Okay, let me clarify here. Burden of proof is not on the boy, it is on the prosecution, the person who's filing the complaint. So, just I'm really sorry, being teacher, it is my responsibility if my student is going wrong. So, it is my ethical responsibility.
No, thank you.
Secondly, what you can answer here is like for a greater good, if we have to suffer losses, first of all we can bear that, okay. Because to create a happy and what shall I say, welfare society, we can talk about that, okay. If lawyers are earning, not earning less, if they are getting less number of cases, no problem, for social welfare we can have that. What else you can answer is the case is diverted to arbitration. They may be lawyers who are playing the role behind it. So it's not like that completely the case has been taken out from lawyer or an advocate. So, in this form, I was expecting the answer. No problem, but you can write a paper out of your presentation and it will be a good paper.
Thank you मैम
Thank you, dear.
Thank you so much, Jyoti, to answer all the questions. Thank you so much, Navdika ma'am, that you gave her valuable advices. So, proceeding further, I would like to invite Nisha Jangvi, a PhD scholar, to present her paper. Nisha, am I audible?
Yes, ma'am. Yes, ma'am.
Kindly proceed.
I need a slide. स्लाइड नहीं आ रही स्लाइड आ ही नहीं रही Good morning, ma'am. Good morning, sir. Role of mediation and negotiation in banking sector. Definition of bank. A bank is a financial institution licensed to receive deposit and make loan. Bank may also provide financial service such as wealth management, currency exchange, and safe deposit boxes. In most current countries, bank is regulated by the national government of central bank. टाइप्स ऑफ बैंक आरबीआई शेड्यूल बैंक अनशेड्यूल बैंक कॉमर्शियल बैंक के अंदर जैसे पब्लिक सेक्टर बैंक एसबीआई एसोसिएट बैंक अदर नेशनलाइज बैंक अदर पब्लिक सेक्टर बैंक प्राइवेट सेक्टर बैंक फॉरेन बैंक एंड रीजनल रूरल बैंक और अनशेड्यूल के अंदर कॉरपोरेटिव बैंक के अंदर अर्बन कॉरपोरेटिव स्टेट कॉरपोरेटिव this banking system largely comprised of scheduled bank that are listed under the second schedule of the RBI Act 1934. Unscheduled bank from a very small component function in the form of local area bank. Scheduled bank are further classified into commercial and corporative bank with the basic difference in their holding pattern. Corporative bank are cooperative credit institutions that are registered under the Cooperative Society Act and work according to the cooperative principle of mutual assistance. Indian Banking Regulation Act 1934, Principal Act guarding banking system in India, Reserve Bank of India Act 1934, second है Company Act और third है Banking Regulation Act 1949. Banking status in 1949. Before 1949, Company Act was applicable for most of the operation. Many banks were in poor health due to low liquidity. Situation was complicated. The mushroom growth of bank and closure and failure of some bank. Objective of Banking Regulation Act to safeguard the interest of depositor, to develop banking institution on sound line, to attune the monetary and credit system of larger interest and priorities of nation. Reason behind Act: no confidence in customer, poor liquidity of bank, fraud, no guarantee of money. Introduction of mediation. Mediation is a structure interactive process where an impartial third party assists disputing party in resolving conflict through the use of specialized communication and negotiation technique. All participate in mediation are encouraged to actively participate in the process. Mediation is a party-centered process in that it is focused primarily upon the need, right, and interest of the parties. Advantage of mediation: fast, flexible, cost efficient, bring party together, convenient, confidential, direct communication. Negotiation in banking. Negotiation is a process by which two or more people or group resolve an issue or arrive at a better outcome, but not through compromise. Negotiation is a way to avoid arguing and come an agreement with which both parties feel satisfied. Negotiation is the most important step in the process of execution of deal. Negotiation with bank is much more different than negotiating with the traditional seller for a potential deal. Advantage of negotiation: it can prevent a conflict from escalating by using preventive diplomacy. It can open wide new area of interest to both parties by expanding the pie. It save trouble and money by resolving in a short period of time disputing. It improve communication, maximum the odd of a positive outcome. It can be used for resolving a disputing and making a deal. Conclusion: it at the end we concluded the mediation and negotiation in a essential scale which a fast, cost efficient party center direct communication and also be used for resolving and disputing of making a deal. Thank you, ma'am.
Thank you so much, Miss Nisha. Any questions for her? Navtika ma'am, Meena ma'am, sir. Faculty members, any questions for her? Am I audible?
Yes, ma'am.
Okay. Okay, so Nisha, can I ask you a question? Yes or no?
Yes, ma'am.
Can you tell me the main difference between mediation and arbitration?
मैम मैंने आर्बिट्रेशन पे नहीं लिया, मैंने नेगोशिएशन और मीडिएशन पे लिया बैंक के अंदर.
Okay, the difference between negotiation and mediation?
जैसे मीडिएशन बैंक के अंदर जैसे लोन के लिए इनमें आता है ना मध्यस्थता इसमें, और ये नेगोशिएशन इसके अंदर जैसे कोई इंटरेस्ट रेट अपन को कम करवानी हो तो अपन नेगोशिएशन थ्रू हो सकता है.
Okay, so can we
डिस्प्यूट.
say that in mediation we can go for a compromise, a balance that both the parties are being satisfied, and in negotiation we
यस
can say
मैम.
a discounting, like to say to reduce or to come or our terms and conditions, right?
यस मैम.
Any other faculty member?
Um, if I may,
Sure, ma'am, sure.
okay, Nisha, is it your doctoral topic, or this topic is related to your PhD thesis?
मैम ये थीम सर ने भेजी थी हमें, संजय सर ने, कि या तो
नहीं,
बैंक
but ये आपके
बैंकिंग
doctoral से related नहीं है ना?
नहीं
Yeah,
मैम.
okay,
नहीं.
okay, good. Nisha, one question only. Nowadays in insurance also we use mediation. So have you touched that aspect, insurance, banking, insurance sector? Because this is one sector, banking and insurance sector. Have you touched that aspect also?
No.
No. It's okay. It's okay. No problem. Thank you.
Okay, ma'am. Thank you.
Thank you so much, Nisha. It was good to hear you.
Thank you, ma'am.
Now I would like to invite Miss Rupali to present her paper. Miss Rupali, a PhD scholar, am I audible? Okay, she is an MBA student. Rupali, am I audible?
Hello. Good morning, ma'am. Yes, ma'am.
Nisha, you can take your presentation back. Stop sharing the screen, please. Thank you. Yeah, Rupali, you may present.
Yes, ma'am. Just a second. Hello and good morning to all. I hope I'm audible to everyone.
Yeah, Rupali, you are audible.
Yeah. So my topic is role of arbitration in family dispute. I'm Rupali from MBA HAHC. I'm here to explain about what is all about arbitration. So the first thing we have to know is about alternative dispute resolution. As we can see, there is a code for every law and order. but there is an alternative dispute resolution also. So, first thing is arbitration. What exactly is arbitration? This one is actually an alternative dispute resolution process. This happens when a dispute arises between two or more parties and this needs to be solved. In that case, arbitration, the parties opt for the dispute to be resolved in a private manner without the involvement of court. The matter of dispute, along with all details, are submitted to one or more arbitrators on a mutual agreement by a parties. So, arbitration of family law means when a husband and wife have some issues, but they don't want that to be like publicly highlighted or it should not be taken to the court. So, they opt for arbitration, in which they privately actually solve the issues. I hope I am audible. Hello.
Yes, you are.
Yes, you are audible.
Okay. Okay. Thank you. And this is not only about the marriages, but also about the marriage, divorce, and the children's custody also. Next one is how arbitrators are appointed. According
Ripali,
to the
sorry to
section
interrupt
11
you.
of the
Kindly,
arbitration, yeah,
Ripali, you can change your slide.
yes, ma'am. Actually, I just changed my
Okay.
slide.
No, no, no. We can only see the first slide.
Oh, okay.
Click on second slide.
Yeah, yeah, I'm doing. Is it okay?
Yeah.
Uh, yeah, okay. So, for appointment, there is a section 11 of the Arbitration and Conciliation Act 1996, which provides the appointment of arbitrator. The section gives the freedom to the parties to assign the arbitrator of any religion, caste, or nationality, but there should be mutual understanding and mutually decided. It should not be like one party is okay with that religion and the other one is not. So, this is mainly about section 11. And then next is marital disputes matters. What matters regarding marital disputes? These disputes generally arises in a few years of marriages just because they are not like know each other. So that's why it was like in the starting of phase. So that phase is very crucial. No one wants to be like go through the court and procedure all. So they opt for arbitrator so that privately they can discuss about the issues and they can solve that like mutual understanding. So some people believe that giving birth to a child is actually a stability that can save a relationship from breaking. But these all things are taken outside the court. Next is divorce arbitration. Arbitration is a process for solving the disputes that have been arises between two parties who are divorcing each other. Just take that place when the divorcing parties want to solve that problem in a lesser period of time without approaching to take the help of court. So that is like this process of arbitrator listening to both parties and hearing and also giving support to like mutually understanding that all things are like arbitrator's duty through which both parties arbitrator will come to decision and consider and will be implied like they will suggest you like for 6 months just stay with each other and all these things. Benefits of divorce arbitration. The parties who want to divorce will find an appropriate person for them who will deal with the problems of disputes and decide. The parties have the right to have an arbitrator who has qualification and interest in it. These parties will have to choose particular day and time of their hearing. Role of arbitration in matrimonial matters in India. So, India deals with the arbitration of divorce for protecting the right of the divorcing parties, which may not be possible in the case of civil courts. But yes, these are the things which is possible in arbitrator, that is a private court type thing. There are two main provisions of which code of civil procedure which regard to the divorce. divorce arbitration in India. That is Section 89 and the Order A6. That is suits relating to matter concerning the family. Alternative dispute resolution is all about in India for gathering justice sooner. For getting justice sooner is actually toughest job. I guess everyone knows that, but yeah, there is an alternative dispute resolution also, which means if court is taking too much time, we can settle that problem privately sooner. It will not take much time. So the need for alternative dispute resolution is actually this only, that for the quick resolve, for a quick solution, not taking too much lengthy process and all. That is what alternative dispute resolution means. Opting out for the undergoing arbitration in India. It is a voluntary process and is not attached to any rules or bindings. Since the parties have a sole right to assign an arbitrator for themselves, they also have the right to stop this and go on the judicial process if they want to. Just in case if someone is not okay with the arbitration, they can opt for the legal procedure, that is from court. Like they can stop arbitration and go for a like officially courts. And there is increasing amount of disputes and fights that are held among parties because of the absence of awareness of alternative resolution techniques. Much more awareness needs to be made in the public, in front of people, for resolving these issues regarding the matters of divorce. For each problem or every problem or personal issues that arises from parties, they cannot go to the court for like each and everything. But yeah, they can go to the arbitrator for their solution. Thank you.
Thank you so much, Rupali. Any questions for us?
Um, I have a question to Rupali. Rupali, in your
Yes,
first
ma'am.
slide, you have mentioned a slogan, "Beti Bachao, Beti Padhao." I just want to know the relevance of that slogan here in the presentation.
Actually, ma'am, the slogan is from our college, like our university.
Okay.
Jyoti Vidyapeeth
Hmm.
is actually all about Beti Bachao and Beti Padhao. So our university use this slogan or represent themselves. So whenever we present anything, we are such very proud of that slogan. So that is why we use that slogan. Like I
Okay.
feel
Okay.
like every
I
time.
understand.
Okay.
I understand. I thought that
Okay.
there is a relevance with your topic. Okay. So, Jyoti, my question now is with respect to your topic too. You have exclusively mentioned about family dispute. Uh,
Yes, ma'am.
but if I'll ask your personal experience, for instance, if you are facing any family dispute, do you yourself will advocate this to go to any of the ADR mechanism rather than going to the traditional court?
Yes, ma'am. Earlier, I was not actually aware of these things. Actually, I was also like, court is the only solution for
Hmm.
everything.
Hmm.
But yeah,
Hmm.
after reading all these things, I am very much attached with this. Like, there is a solution which we can use like for quick solve. If we don't want for
Hmm.
everything just to be like publicly highlighted or something. Yes, okay. If there is someone who can sit and through this process we can sort out our things, I will choose this, arbitrators. Sorry, ma'am, I'm not. You are not audible.
Sorry. Yeah, thank you so much for your reply. And it is the awareness, at least, after studying for this paper, you get to
Yes,
know that, okay, this is also mechanism you can use for your future dispute. So
yes,
it's
ma'am.
my request, to highlight or to aware others also about this, at least in your family and your community around.
Yes, ma'am, I will. And I actually am doing that also. From last 2 3 days, I am counseling everyone for this also.
But make this as an habit. Do
Yes,
not
ma'am.
stop. Yeah, please. Thank you.
Thank you so much, ma'am. Thank you.
Thank you, Ripali. And it was nice that you used a slogan Beti Bachao, Beti Padhao, because we all know that if the girl child will be educated, definitely many family members will be educated. So
Yes,
thank
ma'am.
you so much. Now I would like
Thank
to
you.
call Sakshi to present her paper.
Good morning to all of you. Let me share my slide. Wait, ma'am. Uh, just give me a second, ma'am. Yes. Is it visible?
No, Sakshi, it's not yet visible.
But it is visible. I'm sharing my slide. Wait, ma'am.
Not yet.
Just a second, ma'am. I will
Sure, sure.
share it again. Is it visible now?
Yeah, I guess it will be. Yeah, it's visible.
Okay, a very good morning to one and all. Today, I, Sakshi, research scholar of Jayoti Vidyapeeth Women's University, is going here to present my paper on the topic Family Disputes and ADR, a framework towards resolution. What is alternative dispute resolution? Alternative dispute resolution is a name for several dispute resolution techniques which, while believed by some, are outside the traditional mainstream of state jurisprudence. It is defined as any process or procedure other than adjudication by a presiding judge in court litigation in which a neutral third party participates to assist in the resolution of issues in controversy. In the 21st century era of globalization, clogged courthouses, people inclined either to avoid litigation or to start restoring to extrajudicial remedies. Basically, ADR is a process by which legal disputes are resolved privately and not through the litigation in public courts. And here are the characteristics of ADR. The first one is informality. Generally, ADR processes are less formal than judicial processes. In this, rules of procedures are flexible, that is, it is without the formal proceedings. Second is the application of equality. ADR mechanisms are the instruments for the application of equity. In this case, each case is decided by the third party or negotiated by the
Sakshi,
parties
interrupt you
themselves.
in between. I'm really sorry. Your slides are not been moving.
What, ma'am?
You have your slides which you have shared are not moving, so you have to move them in the
Ma'am, I'm moving it. It is characteristics of ADR. Is it not
Sakshi, we
coming?
can only see the
no,
first
no.
slide. Click on the second or third slide which you are presenting.
Um,
Yeah, yeah. Now we
is
can
it
see the
visible now?
characteristics. It's visible.
Okay, wait, ma'am. Is it the third slide is visible?
Yeah, yeah. We can see the characteristics of ADR.
Okay, okay. Let me continue. The third characteristics is the law is relevant in ADR. Generally, ADR is not deviate completely from law, as legality is a necessary requirement. Fourth, direct participation and communication between the disputants. In ADR processes, there is more direct participation by the disputants, and there is more opportunity of reconciliation between the disputants. And also, there is a self-determination. There is a fairness of processes. And moving, ma'am, my next slide is visible. Meaning of family.
No, we can now. Yeah, now it's visible.
Okay. So the meaning of family. What is family? A family is a group defined by a sex relationship sufficiently precise and enduring to provide for the procreation and upbringing of children. A family is a socially recognized unit of people related to each other by kinship, marital, and legal ties. The family is considered to encourage intimacy, love, and trust, where individuals may escape the competition of dehumanizing forces in modern society from the rough industrialized world arrangements, that is the social security. Now moving to the next slide, that is the family disputes. What is the family disputes? Is it visible, ma'am?
Yes, Sakshi, it's visible.
Okay. Family disputes. Due to the complex nature of family relationship, family conflict can take many forms, that is the verbal, physical, sexual, financial, etc. The conflicts can include the following issues, which I have already written in the my slide, that is disputes between husband and wife, children's education, healthcare and health and welfare, children's behavior, lack of trust, money or debt, financial support for children in the case of separated couples, property disputes, and the relationship breakdown. Uh, Talking about the history of family disputes and its relation to arbitration is institutions at the village level played a principal role, that is a vital role, where the disputes were resolved by the elders compromising the council of the village, that is the properly called the panchayats. The punches with what they pronounce while sitting together as panchayat commanded immense approbation for the reason of well accepted faith that they were the acquaintances of the voice of God. The glimpse of the dispute resolution system of system prevalent in ancient times reveals that the philosophy of amicable and speedy ADR is based on the premise of participatory justice in a family entrenched in the legal history of India. Talking about the family arbitration, family arbitration is a form of private dispute resolution in which the parties enter into an agreement under which they have a right to appoint a suitably qualified person who is known as the arbitrator who adjudicate a dispute and make an award. It can be used to resolve the financial disputes and disputes concerning children. Family arbitration is thus akin to court proceeding in that a family arbitrator will produce a decision after making the evidence and each party's case. In the financial cases, the decision is called an award, and in children cases, it is called a determination. Now, what is the need for a family law arbitration? Generally, arbitration is used for the right in personam. All disputes relating to the rights in personam only are considered to be arbitrable. On the other hand, all the disputes relating to rights in rem are required to be adjudicated by the courts and public tribunals, and hence they are considered unsuitable for private arbitration. The parties also get fear from the power of a judge, uh, whom they have not met, who they don't know who is the judge, and over whose selection they had little or no control, who will determine the course of their and their family lives based on a limited amount of contact and the judge's subjective observation. That is why the parties would like to make their own decision by going through the arbitration. Also, ADR processes have become necessary to counter the problems associated with the adversarial system of litigation in the family matter. Now we'll discuss about the advantages. Fairness. In the ADR processes, both parties generally agree to the arbitral tribunal, which is producing a fair outcome. That is, also parties can directly put their submissions in the way they want it to be decided. Second is the confidentiality. In this, parties generally get the confidence and secrecy what they are discussing among themselves. And the next is timeliness. Arbitration is more quicker than waiting for a hearing date. That is the arbitral process, and also it is a less formal and more flexible in terms of time. The next is the less it is less expensive. That is, it is a cheaper process, and also a failed area proceeding is never a waste. If, for example, if we are in arbitration and if it get and if the conclusion does not come, then it is not a it is never a waste. Now, let us discuss the Law Commission report. What they said is the Law Commission report has recommended that alternative modes of dispute redressal need to be made obligatory in the courts after the issues have been framed. The Law Commission of India, in its 129th report on urban litigation mediation as an alternative to adjudication, has endeavored to bridge the differences between the diverse personal laws in India, particularly in the matters of resolving family and matrimonial disputes. Code of Civil Procedure. All the proceedings in India are governed by the Hindu Marriage Act, and the Special Marriage Act are regulated by the provision contained in the CPC. By an enactment in 1976, the Indian legislature enacted Order 22A in CPC for mandatory settlement procedure in all matrimonial proceedings. Hindu personal laws and the Special Marriage Act, Hindu Vedas, and ancient texts consider a marital bond as a sacred bond that ties both the partners for 7 successive births. This can be traced to the modern governing laws for Hindus, namely the Hindu Marriage Act and the Special Marriage Act. In the Hindu Marriage Act, Section 23(2) states that before proceeding to grant any relief under the HMA, it shall be the duty of the court to make every endeavor to bring about reconciliation between both the parties in all the cases. If we discuss above case, that is the Baljinder Kaur versus Hardeep Singh. In this, generally the parties were there who filed a petition before the court for divorce. Court, before granting divorce, attempted reconciliation. Court they went to the litigation, but court preferred to go in reconciliation between parties, stating that reconciliation as a form of alternative resolution of disputes is mandatory in divorce proceedings. Court then accepted the divorce petition, stating that the main aim should be preserving the institution of marriage and its sanctity. The emphasis should be on bringing parties to mutual agreement and not to focus strictly on the rules of procedure. Now, we will be discussing the conclusion. Agreements prove beneficial not only to the parties but also to the general public. The parties are advantaged through reduced cost and time lost, while the courts are a little less burdened. Efforts should be made to take efforts relating to family disputes in a very different manner, and using ADR mechanism is one of the possible solutions in this 21st century. There is also an urgent need of the day in the current social system to create an efficient legal infrastructure for ADR mechanism in resolving marriages solemnized in India, but also which has been separated abroad. There should be an improvement in the participation of citizens in the area mechanism, and also there is an urgent need for not only establishment of area mechanism in areas in urban areas, but also in the rural areas. Basically, uh, family is the first institution in our country. It is the backbone of the society. Efforts must be made to approach the family conflict issues in very different way, and use of area mechanism is one of the most possible solution in the 21st century in which we are living. Thank you.
Thank you so much, Sakshi. I guess she left.
Sakshi,
Yes, ma'am.
tell me that the time of COVID,
Yes, ma'am.
how the role of arbitration in family dispute matters?
Ma'am, in the time of COVID, generally the cases which are pending, the courts were the arbitration proceedings were going on. As it was not in the public, it is just between the parties. So they are just getting the dates, and on the dates they were just presenting in the court, and they were discussing the matter, so that just I have discussed that the arbitration should be there, so that the parties get their solution as soon as possible. That is in the COVID time also, the parties are going to the court, and the arbitration is going on the time, so that they can justice on the time. If they are not comfortable, then they will get the divorce to the litigation only. But if the court wants that party should settle their dispute as soon as possible.
Yeah, I have one question, and my
Yes, sir.
question is, very practical nature. There are two parties going for the arbitration, two people, you can say, whatever. If one is influencing, have political relations, have relations in governments, have relations with other people, and is influencing the arbitration agency or mediation agency, how to handle that situation, and it happens a lot. Then again,
Yes,
that party is
sir.
deprived of the justice. So ultimately, it is the power game. So that is something which is alarming. So what are your views about that?
Sir, you are right. Basically, in today's world, it is all about politics. If a person is having a politics in his hand, the case will go in his favor only. You are absolutely correct. But, sir, the arbitration process generally that focus on that focus कि दोनों के लोगों के बीच
No,
में
my my
आराम से
my. My question is: there any regulations to control these arbitration agency, mediation agency? They are coming up every other,
sir, yeah,
every other,
yes, they are.
every other day. I can use the word. There is no harm in that. If you go and Google, you will find tons of mediation agency, tons of counseling agencies, arbitration agency, this and that. So, is there any regulation? Because if these are regulated, then definitely they will think twice before getting influenced by the influencing people. That's what I want to add.
Sir, that I have to read in vast.
Yes,
I'll go through
that is
that.
something. Yeah, that is something is
Yeah.
to be
Yes, sir.
discussed.
This is a nice research
Whether,
that I will go through
whether
it.
these may also be regulated.
Yes, sir.
Anyway.
I'll go through it.
Okay. Thank you so much. A wonderful
Thank you so
question
much.
by President Sir.
Yes,
And I want to add what Sir has said, that Sir, we have regulatory mechanism to regulate arbitration, mediation, and conciliation. Because how it happens, other than mediation, arbitration and negotiation, even conciliation happens through court only.
Okay.
But for mediation also, if parties are thinking, and this will not this will not be in domestic violence or even divorce cases. For example, it is a maintenance case, they can go for a mediation, and the mediator, they both have to appoint. So we have established rule for mediation, and we have established law for that. 1996 act is there for it. Even problem comes with the order, whether the order has a binding effect or
Or
not.
not. Yeah.
It is not. If it
Okay.
is not established through court, then the order
No
will
one will,
not bind
no
on the
one
party.
will obey
Yes,
that
sir.
naturally.
So yes, so Sakshi, a question, if
yes,
ma'am
ma'am.
allows me. Sakshi,
Yes,
wonderful presentation.
thank you.
I have a question, that what do you feel, which mechanism is better with respect to divorce cases? In ADR,
Mediation.
we have mediation. Why?
Um, Ma'am, because generally, if two people sit together, that is the husband and wife, then the third party can uh, give them a good solution. You can go through this, you can go through this. If they sit together, if husband and wife sit together, they will not able to decide in which direction they should go. But when the third party tells the benefits, that it should be like this, it should be like this, then they can focus on this, and yes, they can prefer, okay, maybe he is right, we can go accordingly, and let us give more time to each other. For me, the
I'll give
mediation will be most. Yes,
But
ma'am.
here I'll give you a practical problem here. What happened is, if the
Hanji.
mediator himself is facing some matrimonial issues, for example,
Okay.
she's a female, okay, and she herself is facing some domestic abuse at her place, but because of this status, because this happens, because of the
Yes, ma'am.
status, we cannot come up with our issues that I am also a sufferer, okay. So
Hmm.
but that will come in the closed door, when she will be providing her mediation to the person, because that person is not psychologist. The problem with
Yes.
mediation center which I faced is, the person may be having a knowledge of law, but that person does not know the knowledge of psychology and sociology.
Yes.
So this another suggestion you can give in your paper, that the mediator
Yes, ma'am.
shall have the knowledge of psychology and
Yes,
sociology.
right.
Yes,
So
ma'am.
because it is connected to three of the
Yes,
situation.
ma'am. This is obviously the logical, and also when the mediator is appointed in the court, there should be a qualification that he should have done this
Yes.
course.
Absolutely, absolutely.
It's not like that anyone is coming and doing the mediation. That
Yeah.
that
Yes,
Absolutely,
ma'am.
sir.
sounds,
And this
yeah.
is
A very good
happening, sir. This is
suggestion. Yes,
happening in
ma'am.
real court. This is happening, sir. A judge who has basic knowledge that becomes a mediator. There are past experiences of that person which impact his future mediation cases,
Absolutely.
and that is why it's fail also. That is
Yes,
why we are not reaching to conclusion. This is one of the reason of failing mediation cases.
you are right, ma'am.
So this was only a suggestion. Thank
But
you.
your presentation was good, Sakshi,
Thank you,
and it was
sir.
good to hear. Yeah.
Thank you,
Wonderful
sir.
presentation you gave.
Thank you for the
Thank you.
questions and the suggestions which were given. It gave me more to research on it. Thank you so
Absolutely.
much.
Sakshi, it was genuinely good. You covered all the advantage, disadvantage, retrospective effect, prospective
Thank
effect
you,
of
ma'am.
arbitration. It was genuinely good to
Thank
hear you.
you.
Thank you so
Thank
much.
you. Thank you.
Now, I would like to invite Miss Kiran, a PhD scholar again, to present her paper. Kiran, unmute yourself. Am I audible? Kiran, am I audible? She is joining soon. Just a second. Kiran, open your screen and unmute yourself. Kiran, am I audible to you? Kindly unmute. Kiran, you are visible but you are not audible. There is a mute button. Unmute yourself. You clicked it. Clicked it once again. Click the same button once again. Yeah. Now say. Once again. Click the mute button once again, Kiran. Kiran, you are not audible. Am I audible to you?
अनम्यूट अनम्यूट का बटन आ रहा है उसको क्लिक आपकी आवाज नहीं आ रही अनम्यूट नहीं अनम्यूट एक बार उसको क्लिक
Kiran, I guess there is some network issue. So we'll wait for 5 minutes. Till then we'll continue with other presentations. Right? So kindly stop the screen. Stop sharing the screen. Thank you. We'll connect you after 5 minutes. So I would like to invite Kiran Gupta, Jyoti Sharma, and next is also Jyoti to present their paper. You may start.
Good morning, Honorable Advisor Sir, Chairperson Ma'am, Pro-President Sir, Dean Sir, and Speaker Guest, and respected teachers. I, Javelin Kiran Gupta, person BSc Agriculture plus MBA 10th semester, going to present my research on the topic Mediation is Customer Dispute. Mediation as a mode of alternate dispute resolution has a long history in the diplomatic arena. Mediation is a form of alternative dispute resolution in which parties resolve the dispute themselves with the help of mutual mediator. The mediator does not make a decision but help the disputing parties to find the solution that is acceptable to all parties involved. One of the major advantages of mediation is the fact that relations between the disputing parties are not unnecessarily damaged. Still, there is scope for creating awareness among the consumer and business entities to popularize mediation and make things the mediation as an effective tool of ADR. Here is the different terms. First one is dispute. Dispute means disagreement or holding opposite views between the two or more persons on any point. Disputed parties. Parties claiming different interests or rights and holding opposite views in disputes are referred as disputed parties. Third one is negotiation. Negotiation is a process where two or more parties having conflicting interest in any disputed bargain among themselves to reach a settlement where they can both agree on. Mediation. The term mediation can be defined as voluntary dispute resolution process where the third parties facilitates negotiation between the disputed parties to negotiate for their rights and interests by themselves. Mediator. Mediator is a neutral and impartial person who carries out the process of mediation between the disputed parties. There are two types of mediation. First one is court referred mediation. The court may refer a pending case for mediation in India under Section 89 of the Code of Civil Procedure 1908. This kind of mediation is often used in matrimonial disputes, particularly divorce cases. Second one is private mediation. The private mediation is one where qualified mediator offers the services of mediation on a private fee for services basis to the court, to the member of public, to the member of commercial sector, and also to the governmental sector to resolve disputed through mediation. Private mediation can be used in connection with disputed pending in court and pre-litigation disputes. Now, I would like to invite Jyoti Sharma.
Good morning, advisor sir. Good morning, chairperson ma'am, vice chancellor sir, faculty member. I like JVN Jyoti Sharma, BSc Agriculture plus MBA 10th semester. Mediation of advantage of mediation, greater control. Mediation increase the control the parties have over the regulation. Each party are directly involved in negotiation. Their own agreement and on statement can be improved upon the in comparison. This certification is often exercised in court where parties have little choice but to accept the judgment made which they may not be happy with. It's confidential, unlike the political publicity of court producing everything said at the mediation is entirely confidential to the parties, unless especially agreed otherwise. It's voluntary and party any withdraw at any time. Conventions. The mediation is arrangement at an convention to the parties how each have their own room as well as a separate room. For joint meetings, the mediators listen to everyone, being talks to the parties privately and together, judging them towards a settlement. Reduce cost. Generally, the cost is greatly reduced the comparison with trying to settle the matter through court. Traditional litigation is very expensive and the total cost is highly unpredictable. Faster outcomes because mediation can be used early is a dispute and agreement can easily be reached quicker than is pursuing through the courts. Support mediators are trained in work with difficult situations. The mediators act as a natural facilitators and support each party through the process. Resolution of relationship, where it may be a business or family disputes, preservation of resolution can be key benefit of meditation. Meditation helps participants focus on effectively communicating with each other as opposed to attack each other. I look like to invite Jyoti Sharma.
Good morning, sir. Good morning, sir. Chairperson, ma'am, Dean, sir, and faculty member. I, GVN Jyoti Sharma, pursuing BSc Agriculture 10th semester, going to present my result. Consumers who experienced problems with the court or ADR were less likely to say they would use them again in future to resolve a similar dispute. Or those consumers who reported a problem, 50% of those who used a court and 48% of those who use ADR said they were likely to use them again in future. The likelihood is using the ADR court again consumer who have not experienced a problem is significantly higher with 88% of ADR consumer, and 81% of court consumers like to use the respective redress mechanism again in the future. Conclusion. This study found that most consumers who use ADR or court had a good experience. 76% of consumers who used the court and 69% of consumers who use ADR said they were likely to do so again if the experience is a similar problem in future, where the outcome of the case was in favor of the trader or a compromise. This figure dropped to 66% and 43% represented the most common problem when using the court include longer duration, then the lack of communication and information on the process. The problem most often cities by consumer who use ADR were having to follow up several times with the ADR provide and perception with the process favored the tender. In particular, in case where decision was taken in favor this the tender. These are references, and thank you.
Thank you, students. Thank you, students. Any questions for us? Any questions for them?
Yeah, it's a wonderful presentation. Three of you have good, did a good attempt. Uh, Small, clarification. What is your object of, this topic?
Which was mediation in consumer disputes.
The objective. I'm just asking. When we do some research, we take an objective of the topic. No problem. Thank you so much.
Thank you, students. Okay. So now I would like to invite Neha, a PhD scholar again, to present her paper. Neha, am I audible?
Let me share my screen.
Sure.
Ma'am, is it visible?
No, Neha.
Just hold on, ma'am.
Just a second, Neha. Sakshi, a question for you that you have presented your paper, right? Sakshi, am I audible? If you have presented your paper, kindly leave the studio because we can only enter a few number of candidates.
Ma'am, if you can you
She's
please
not
guide me how
Sakshi.
to share the
She's
screen?
Neha.
Yes, Neha, you
Ma'am, can you please guide me how to share the screen on
do
this
one thing. Look,
platform?
you click on the PPT, right? Open it.
Okay, कर दिया ma'am.
Yeah, we can see it now.
Is it visible?
It is visible, but come from first slide. Yeah.
Yeah.
And you
Yes,
can
ma'am.
see just as Neha. Now we can see it properly.
First of all, a very good afternoon to all my respected authority, and I'm really thankful to all the authority for giving me this platform to present my research paper on the topic scope of mediation in India, challenges and recommendations. First of all, I would like to start with the introduction part. It is a well-known fact that the Indian judiciary is the oldest judicial system. But it is also known that the Indian judiciary has become inefficient in settling the disputes because of the Indian courts are clogged with thousands of cases and the cases keep on piling up. Even the small matters which can be discussed outside the courts are also filed before the courts. Moreover, most people no longer have time to go and file papers at the court and then wait for long period for a hearing. That's why ADR has been introduced and we are approaching a stage where litigation is being replaced with the ADR. The purpose of solving dispute through ADR to lower the burden of court and provide speedy trial and to ensure justice. Now, what do you mean by alternative dispute resolution? ADR refer to techniques, alternatives, method which help parties in the dispute to come to a settlement without going to court. These methods usually involve a third party to settle disputes between the transacting parties. It allows the parties to understand each other's position. It is based on Article 14 and Article 21 of the Constitution of India. Types of alternative dispute resolution mechanism. First is arbitration, then mediation, conciliation, lok adalat, and negotiation. What are the merits of ADR? ADR resolves cases quickly without much delay and incur less expense as compared to litigating a case in court. ADR allows the parties to work together with a neutral and independent arbitrator or mediator so that disputes get resolved quickly and parties get satisfied. ADR process can be initiated at any time. ADR method involves the knowledgeable professional to resolve the dispute. Alternative dispute resolution is a private process, whereas courtrooms and court records are open to the public. ADR methods are less stressful, less expensive, and not that lengthy. It is an effective process, and mediation, if I talk about mediation, it generally enjoys 80 to 85% of success rate. It affords party to the opportunity to exercise great control over the way their dispute is resolved. Unlike court decisions, which can generally be contested through one or more round of litigation, arbitral awards are not normally subject to appeal. What are the demerits of ADR? Like most of the people are they're not familiar, unfamiliarity of the process is a factor causing obstruction in ADR. The rights of the parties may not be protected by alternative dispute resolution. Parties are not compelled to continue negotiation or mediation. There is no guaranteed resolution of dispute. Decision reached in ADR may not be binding on the parties. The final resolution to the dispute is open to the parties either to reject or accept. In ADR, there is the absence of legal precedent. Ma'am, am I audible?
Yes, Neha, you are audible.
Now, let's talk about the mediation. Ma'am, basically mediation, it is a process of talking to two separate people or group involved in a disagreement to try to help them to agree or find a solution to their problem. It is the most popular form of ADR and it is the first and foremost a non-binding procedure. It is also an informal alternative to litigation. It is an old procedure of dispute resolution. It is voluntary. It is voluntary, party-centered, non-binding, confidential process where a rational and neutral third party who possesses special communication and interactive skills to facilitate a mutual settlement between the parties. In mediation, the parties settle their dispute on mutually agreed terms. It is a process of dispute resolution in which the third neutral person, help to resolve the issue or conflict of disputed parties through the method of specialized communication and techniques. It promotes active and direct participation of the parties. In mediation, the role of mediator is to help the parties in communicating and negotiating more effectively so that they can reach the decision quickly. And today, if I talk about today's scenario, it has become the most fast growing form of ADR. Now, what is the scope of mediation? The scope of mediation in India is very high. Court refers to huge number of cases as mediation. Many cases arises on a daily basis and these cases increase the burden on the court. Court procedure take too long in delivering justice, therefore people prefer to opt for the ADR system as the ADR provide fast and satisfactory solution. Mediation plays a very important role in understanding the stage of dispute and why they arose and also the way through which the parties want to settle the dispute. because the mediator is selected by the choice of parties, and the parties know which person as a mediator will consider to be the best for resolving their dispute. The irony is that the court itself cannot refer the case as mediation. They have to take the permission from the parties before referring the case for settlement for mediation. Ma'am, there are many mediation. There are many benefits of mediation. Like it is affordable, it is fair, it is impartial, it saves time, it saves money, it is confidential, it improves the communication, and it identifies the underlying issues. And ma'am, in mediation, there are 4 stages. If I talk about these stages, it is divided into 4 points that are introduction and opening statement. Next is joint session. Third is separate session, and last one is closing. And if I talk about the objective of mediation, the objective of mediation is to establish the neutrality, create awareness, understanding of the process. It gain the confidence and trust of the parties and motivate them to reach the amicable settlement. Now, ma'am, the next one is legal framework of mediation. There are 2 principal achievements that tackle mediation in India. Unlike arbitration and conciliation, which are governed by the Arbitration and Conciliation Act 1996, there is no umbrella legislation governing mediation in the country. The provision of Section 89 of the CPC empowers civil court to refer civil dispute to, among other things, mediation where it appears to the court that there exists element of settlement which may be acceptable to the parties. Ma'am, basically Section 89 of CPC, it is itself a welcome step toward promoting the mediation and other means of ADR. As per Section 89 of CPC, if read with Order Rule 1A or Order 10 Rule 1A of CPC, after recording the admission and denial of document, the court shall direct the parties to opt for any mode of settlement outside the court. Next is Legal Service Authority Act 1987, read with Section 89 of CPC. Legal Service Authority at the center, state level are authorities established by the Legal Service Authority Act 1987 with the object to provide free, competent legal services to the weaker section of the society and to ensure that the justice is not denied to any citizen. Ma'am, the next one is 129th Law Commission of India report. It recommends court to refer the dispute for mediation compulsory. Next is Section 12A of the Commercial Court Act 2015, and Chapter 3rd of this Chapter 3rd A has been inserted by 2018 amendment to this Act, which clearly states that a suit which does not contemplate any urgent interim relief shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure prescribed. Now the next is, ma'am, what are the challenges in mediation? Though the mediation is speedier, cost effective, and offer great possibility of preserving the relationship between disputing parties, but the existing mediation framework in India has not allowed to bring its full potential. There are various type of challenges that are faced by the mediation process, like lack of codification, lack of authority over solution, lack of awareness, apprehension toward mediation, infrastructural concern and quality control, inconsistency between the mediation and the existing laws, lack of training and support. Ma'am, there are many cases as well which deal with the mediation, which talk about mediation, like judicial precedent related to mediation. First is Salim Bar Association versus Union of India. In this case, the Honorable Supreme Court observed that the provision of Section 89 CPC has been inserted to ensure that all the cases which are filed in the court need not necessarily be decided by the court. The Supreme Court opinion the need to promote ADR. Now, the last one is recommendation. Mediation is the need of the hour. Legislation should ideally aim at making mediation a mandatory exercise before approaching court or arbitral proceedings. In order to aware people about mediation as a dispute resolution mechanism, training sessions and seminars should be conducted to familiarize judges with the benefit of mediation. Public awareness related to the mediation should also be increased. Lawyers should also be encouraged to advise mediation to their clients, and the recent proposal of the Bar Council of India to compulsory include mediation in the legal curriculum will definitely assist law students in taking up a career in mediation. In the court, mediation center make all the arrangement for refresher courses. Thank you so much, ma'am.
Thank you so much, Neha. It was a nice presentation. So, any questions for Neha?
Neha,
Yes, ma'am.
am I audible, Neha?
Yes, ma'am. Yes, you are audible.
Okay, I want to ask for one question for you. That is there any need to increase mediation center awareness?
Ma'am, yes, there is a need to increase the mediation centers because as we know that the cases are increasing day by day, and especially the matrimonial cases, which like in which four cases come free with the one case. There is a need of mediation center because जितने ज़्यादा mediation centers होंगे, जितने ज़्यादा proper trained specialized people होंगे, उतने ही जल्दी like cases sort होने के chances होंगे.
So, as a research scholar, your contribution?
Ma'am, matlab my till date I have not contributed. Like initially, I was practicing in court, and I have seen many matrimonial disputes. And during that time, I have personally advised the parties how they can reconcile, how they can mediate their matter peacefully, how they can reach the a conclusion, and how they can settle their dispute amicably, without any grievances or grudges toward each other, because
एक और बात
ultimately
बताओ.
it will harm their relationship only.
Actually, what is the basic difference between a conciliation and mediation process?
Ma'am, basically the difference between mediation and conciliation is mediation is a proper.
You are not audible, Neha.
She left the
Yeah,
streamline.
I guess she left. Maybe there is some technical issue. She came back. She joined us.
मैम एक्चुअली बेसिकली द मेडिएशन इज लाइक इफ आई मतलब अगर मैं आपको एक प्रॉपर हिंदी वाले वे में एक्सप्लेन करूँ तो मैम जो मेडिएशन है वो एक प्रॉपर स्ट्रक्चरल प्रोसेस है, एंड जो कंसिलिएशन है इट इज नॉट अ फॉर्मल प्रॉपर स्ट्रक्चर प्रोसेस. लाइक इफ आई टॉक अबाउट मेडिएशन, इसमें आई टोल्ड यू देयर आर 4 स्टेजेस, एंड बट इन दीज 4 स्टेजेस और दीज 4 पॉइंट्स आर नॉट फॉलोड इन कंसिलिएशन. एंड सेकेंडली कंसिलिएशन में लाइक क्या होता है, एक फैसिलिटेटर होता है एंड ही एक्ट लाइक अ एल्डर ऑफ द फैमिली. लाइक एक सलाह देते हैं ना, एक राय देते हैं कि चलो फटाफट सॉर्ट कर लो ऐसे या वैसे. बट इन केस ऑफ मेडिएशन जो मेडिएटर होता है ही डायरेक्टली do not give any advice कि ऐसे करो वैसे करो. He try to understand the dispute. He try to understand the nature of the dispute by putting the questions and answers round, so that while answering the questions of mediator, parties itself realize where they are lacking and where there is मतलब where there is lacking and actually में कहाँ किसका fault है, वो आंसर देते देते ही उस वाले पॉइंट पे रीच करते हैं. बट इन कंसिलिएशन लाइक एक एल्डर पर्सन सलाह देता है कि फटाफट ऐसे कर लो, क्या करोगे लड़ाई करके या ऐसे. तो ये डिफरेंस है.
आप वो एक्चुअली में है ना, कहते हैं ना कि घर की बात घर में ही रह जाए तो बेटर है.
राइट मैम, राइट.
एक्चुअली में एडीआर का मेन तो पर्पस, आई थिंक नम्रता मैम, एम आई राइट? डॉक्टर नम्रता.
Absolutely, ma'am. And in family dispute,
Especially in family
reconciliation
matters.
happens more.
Yeah.
मैम इनफैक्ट आज भी मोस्ट ऑफ द पीपल दे थिंक कि लाइक कोई इशू ना बने या हमारी सोसाइटी में एक रिस्पेक्ट बनी रहे, से और दे ऑलवेज ट्राई टू सेटल देयर डिस्प्यूट्स और सेटल द इशू बिटवीन द फैमिली मेंबर्स ओनली. दैट्स व्हाई देयर इज अ नीड टू अवेयर मोस्ट एंड मोस्ट पीपल अबाउट दिस ADR process, that if they will come out with their dispute before the mediator, then also their matter will be safe and it will be confidential and it will not go out. So that, then only they.
Yeah, I'm also agree. Privacy and confidentiality is must. Even it's
That's why they, it is our duty to aware them.
Yeah.
Yes, yes.
Because that is the biggest fear the people have,
Right.
and they don't want to come out with their, what is going on with them.
Right, sir.
Due to
Right.
the
With
goodwill of the
society.
family.
Yeah.
Right, sir. Right.
Okay, Neha, fine.
Thank you so
Okay,
much, ma'am. I am
thank you so
really
much.
thankful to all the authority for giving me this platform. Thank you so much.
Thank you, Neha. So now I would like to invite Ashu Gupta to present her paper.
Actually, you are not audible.
Am I audible, ma'am?
Is she audible now?
Yes,
Namaste, ma'am.
Sakshi.
Beena ma'am, is
Actually,
Asha
continue.
audible?
Namaste, ma'am.
Hi.
Yes. Okay. Namaste to everyone. Good morning. Respected Pro President Sir, Director Sir, Dean Ma'am, Dean Sir, Director Ma'am, and the faculties and the guests here, and the person who are present here. I'm Asha Gupta, pursuing BLLB fourth year. I'm here to going to present my PPT on the topic of role of arbitration in family disputes. So here, I'm talking about how arbitration law is evolved in India. So the evolution of modern arbitration law in India is through in the form of panchayat. Earlier than the Britishers came in and set up their authority here. Now, later on, ADR developed with the imminent of the East Indian Company. Then after Britishers made some legislative form to the law of arbitrations and made policies in three different towns. That is called the presidency towns, which means first one is Calcutta, second Bombay, and third one is Madras. Then after League of Nations came arise, which was supposed to bring the sector nearer through the trade, which made it realize the significance of arbitrations. From such a result, the Protocol on Arbitration Clauses in 1923 came into existence, and this convention is also known as Geneva Convention of 1927. After several years of work, in 1958, the world came up with a convention that is the new convention, which is still in running. Then after many acts came here, Arbitration Act of 1940, which was repealed and replaced by the Arbitration Act of 1960, and this is repealed by the Arbitration and Conciliation Act 1996, which is still in running. So after knowing about the evolution of modern arbitration law in India, I'd like to tell you about the scope of future research. So once Abraham Lincoln once said, discourage litigations, persuade your neighbors to compromise whenever you can. The nominal winner is often a real loser in fees, in expense, and waste of time. So here, I would like to tell you about how ADR mechanism turn out to be an important for resolving family disputes in India. So ADR is necessary as a substitute to existing methods of a dispute resolution such as litigation, conflict, violence, and physical fight situations. ADR is a kind of method which resolves conflict between the parties that is more cost efficient, rapid, non-violent, and satisfactory. There have been contemporary developments in ADR, and now the COVID, at the time of pandemic in 2020, online dispute resolutions came arise, and the ground allies with the pandemic since 2020. The court system have revolutionized the hearing process, and this revolution has helped to save the time, money, and mental and physical confusions that usually occurs during proceedings. These agents will expand the scope of ADR in India. After knowing about the scope of future research, I'd like to tell you about the objective of ADR. So ADR is a kind of a dispute resolution which is very helpful to the parties because it's made remove the burden of courts, and it is kind of procedure which can support not only the legal objectives but also supports and provide other developments of objectives such as economics and social objectives by facilitating the resolution of disputes. So here are kind of disputes. First one is win-win outcome. That means negotiation between the parties. Here, no one parties can lose. Here, the parties having the kind of solution which they have in kind of arising their dispute with satisfactions by the adjudicator. Second one is cost effective or no cost at all. It's as compared to litigations, ADR technique is much more cost effective. Third one is require less time. As you all know that the litigation takes so much time at the time of trial, but ADR is helpful because without trial it gives you the best solutions ever. Next one is reconciliation between disputants. And last one is positive outcome. Encourage other to resolve dispute in the community. So the parties between whom dispute arise. So the ADR is a main motive to reconcile them and encourage them to take the ADR process to solve their disputes without outside the courts. So after objectives, I would like to tell you about what is ADR. So ADR, alternative dispute resolution, is just an alternative to the litigations. and they are informal, inexpensive, and faster than the traditional proceedings that is known as the litigations. And it has a kind of ADR mechanisms, first techniques also. First one is arbitration, second conciliation, third mediation, fourth negotiations, and so many more, like a Lok Sabha, and which is having a statutory authority by the Act of Legal Service Authority 1987, which is very helpful. And that made ADRs turning into well famous techniques for resolving disputes between the parties, especially in the commercial enterprise disputes and also the family dispute as well. These techniques permit the parties to make choice about rules that can be relevant to those complaints. And these methods, in the maximum of the proceedings, use a third party, which is impartial, which also knows an adjudicator. If they choose arbitration, so it's known as an arbitrator. At the time when they choose a conciliation, is he known as a conciliator. So he chose a impartial third party, which is selected by the parties own with their own consent, or by through the courts. It ensures the parties regard the method and adjudicator because those procedures make people empowered. So, after I would like to tell you about my topic. My topic is the role of arbitration. So, what is arbitration? So, arbitration is a form of dispute resolution in which the party choose to resolve dispute by avoiding going to court and instead appointing a third party known as arbitrator. Arbitrators are appointed to solve the labor disputes, commercial disputes, consumer disputes, and family law issues. Arbitrations can only be initiated if there is an arbitration agreement between the parties before the disputes. So arbitration is also known as a pre resolution technique because it made an arbitration agreement before dispute arises. And according to Section 7 of Arbitration and Conciliation Act 1996, mentions that an arbitration agreement claimed by one party and no dispute by the other party shall also be considered a valid written arbitration agreement. There are only two reasons parties can challenge the appointment of arbitrator. First one is when there is a reasonable doubt about the fairness of the arbitrator, when they chose a third person as an impartial, but after that when he becoming impartial, so that they have a reason to about the fairness of the arbitrator and they have reason to challenge him in the front of the court. Second one is lack of proper qualification of an arbitrator under the arbitration agreement. As a party has a right to choose an arbitrator without any qualification as well. If he is not a lawyer, so he is right to choose a third person who solve their dispute. But when he has not a proper qualification, when he is not aware about the dispute matter or the how to solve the matter, so they have a right to cancel the arbitrator agreement as well. Later on, after arbitrations, my PPT was want to tell you about the arbitration outlook. Therefore, is a preferable. So, what is the why the approach of arbitration is held to be taken? So, because the first one is technical expertise. Because arbitration process is much faster and more cost effective than that of a court. And second one is free to decide the place and time of the proceeding by the convenience of the parties. Third one is the privacy and the confidentiality, as parties are maintained as there is no unnecessary publicity about the dispute. Next one is arbitrators are more flexible than courts as they are not subject to the same strict rules and regulations as a court scenes. The rules are set only by the parties. This is because these advantages of arbitrations, the parties prefer it and give it the parties full authority to decide on their arbitrations. And much more important because court has a more burden nowadays, so that's why ADR is very helpful to them to remove their burdens. Later on, arbitration methods, which is used in India for family disputes. So, family disputes which arise like a child custody, marriage, divorce, maintenance, and the property matters and etc. So, yes, India had relate to arbitration to protect the right of the parties. This may not happen in the case of civil court, but that is why arbitration is preferred. But here it can be done according to the law. Arbitrator can only decide the important thing only. There are two main provisions of civil proceedings which is relate arbitrations in India, which are Section 89 of CPC, Civil Procedure Code of 1908, which provide under Section 89 to resolve dispute outside the court. And the second one is Order 32A, 6, which define the suit related to matter concerning family problems. And also constitutions also provide the provisions related to the arbitration under Article 39A, which is mentioned free legal aid, and second one is Article 51, which is talking about when there is any international dispute arises between the parties or the parties, so arbitrations have to be taken at that time. Later on, what is family arbitrations? So, family arbitration is a way to resolve disputes between separate couples, whether married or not. It can help with disagreement, relate to money, properties, and as well as arranging for children, that is known as a child custody. In arbitrations, the goal is not to reach a negotiated agreement, but to have someone else to make the final decisions for you. This is very crucial when negotiation fails and both parties need a fixed outcome so that can move on with their family lives, as there are several case precedents regarding family disputes in India. First, one is Manas Acharya versus State of Andhra Pradesh. In this case, court emphasized that the solution reached through mediation are lawful and correct, and that decision made during mediations are binding in all respects. After, what is my research outcomes for resolving family disputes making? So ADR is provided the parties to a dispute with the opportunity to resolve a controversial issue with the help of an impartial party. It's generally faster and much less than going to court. Disputed matters are treated amicably, which is friendly to the court without affecting the interpersonal relationship. Next one is it's a family relationship from the emotional problems they may face due to long court process. This is also advantageous if parents need to stay in touch with their child after divorce. And next one is it protect privacy, as I told you before, that it's allow the parties to open about which alternatives they would like to consider. But this is not applied to litigation proceedings. Next, and the last one is even if the proceedings make family issues ugly, the parties can discuss and reach an agreement in mediations. This lead to being happier about the choices they are making. Now, lastly, I conclude my topic, I would like to tell you about the ADR techniques, which is namely is arbitration, conciliation, mediations, and offer significant advantages to the parties and can be seen as complementary to the adjudications approach. Areas allow to parties to develop realistic, low cost, and sustainable arrangements. Over time, family arbitration became embedded in the legal culture of India, and over to 5 to 6 years following the advent of binding family arbitrations, this fact should get all possible support and choose friendly arrangements that benefit the parties. Thank you so much.
Thank you, Ashu.
Yes, I have one question, and my question is very basic, but you have to clarify it. So
Yes.
be sure. What is the difference between mediation and arbitration?
So actually, arbitration is a kind of informal process, and the mediation is the same. Both are the techniques of ADR, alternative dispute resolutions, and arbitration is like a resolve dispute before outside the court. But when a party choose the court, so court has an option if they decide that if this case is solved by the outside the court, so they refer the parties to the mediation, which are very बहुत ज़्यादा ये they were uh, mediator according to section 89 of the CPC. The parties,
Okay, hold
court
on.
are
You
refer the parties to the.
yeah. Is it necessary in arbitration that both parties must be agree 100%?
No, sir.
And they
It's
should,
depend upon the parties. If they are satisfied with the decision of the or the
or are they bound to the decision
decision
of the
of the arbitrator.
arbitrator? Whatever he is saying in the best interest of one party, in the best interest of another party, both have to obey.
Sir,
Because in
actually,
mediation is
arbitrators
very
are
clear. Both
impartial
have to
parties.
sign and get with the issue mediated through the mediator. Tell me,
Yes,
I'm
sir.
asking a very basic difference, which you have to tell. Or
Okay,
other
this is the basic
experts are
difference
here, they
between the
can also
arbitrations.
put their
Sir,
views.
arbitration is a kind of procedure which dispute submitted to an arbitral tribunal when makes decisions that is called an award on dispute and which is binding on the parties. And
No.
mediation is also a mediator as an impartial party which work with parties to find a
Dear
solution
sir,
which
dear,
acceptable to
hold on
all of them.
yourself. Dear, hold on yourself. Sir is asking very basic question, and you have to understand question first before answering. I know you are excited and you have done a wonderful presentation,
Yes.
but sir is asking some other question. Just hear him properly and then answer. I'm really sorry, sir. Please, over to you.
So can you please repeat the question?
My question is, what is the basic difference between mediation and arbitration? And is if both the parties are not agree, is still that decision given by the arbitrator is bound to the parties or not?
Okay, sir. So, firstly, both are the techniques of ADR. Arbitration is a process which have their own arbitral tribunal, which make them award according to the future disputed matters. Because always arbitration is chosen by the contractual parties, and then they decide according to the future disputes. If their future dispute arises, then they going with the arbitration, because in the arbitration agreement they made the future arbitration clause. Whenever our dispute arises between the parties, they choose. And the mediator is a kind of third person which is chosen by the parties. And the main difference which you asked about for me, that is, when parties case is going before the court, and court is satisfied that this case is being settled outside the court, so they refer under section 89 of Arbitration and Conciliation Act, and they having a very transfer mediator, and they
No, no, I
help
think
to make them settle the
our
case.
today's expert, Dr. Navtika, is getting the question and he
Yes,
can answer.
that's why I'm so reluctant to answer.
Yeah, yeah.
But before answering, what is your title of the presentation? You forgot.
Then role of arbitration in family disputes.
No.
In family.
Ad
Role of
hoc and
arbitration in family disputes.
ad hoc
Then,
and just read from your slide the title of your presentation, because
then
sir,
role of
your
arbitration in
question
family
answer
disputes.
in there. Role
Yes.
of
Role of arbitration in family disputes.
this is the top title, not title of your presentation.
Ma'am, this is
Okay.
my title.
Okay. So, sir,
This
the
is
basic
starting.
difference between the two is uh, arbitration is of two types, ad hoc
Yes.
and institutionalized. If
Yes,
it is
ma'am.
ad hoc, that means both the parties themselves decide the arbitrator. So, it is not binding. If
Okay.
it is institutionalized, then that means the arbitrator is appointed by government.
Absolutely. That is the answer. That's why I did
Yeah.
ask you. It was
Yes.
one line.
Okay. Okay.
Yeah. It is bound.
No,
In that case, if it is institutionalized. In
if
case of
it is
mediation, both parties have to
institutionalized,
sign the agreement.
Okay. Okay.
And the mediation is done by a mediator. That was the
And
simple difference I was, trying to ask from you.
one question. I have one question for you, Ashu.
Yes, ma'am.
Tell me, if I am not satisfied with the arbitral award, okay?
Hmm.
So what can I do?
Ma'am, actually,
Can I go
arbitration.
appeal? Can I go for appeal?
Yes, ma'am. According to Arbitration and Conciliation Act 1996, under Section 36, you have a right to choose the appeal procedure against the arbitration award. So here's the answer.
Yes. So
Fine.
that was the difference. So you should understand that it is written at many places.
Yes, sir.
Yeah. Nowadays, it's pretty easy to interpret the things and find out. So anyway, you tried. That's good. That shows your
Thank you,
courage,
sir.
and your presentation was also good. What's your
Thank you,
name?
sir.
What's your name?
Ashu Gupta.
Ashu Gupta. Yeah. Nice
Yes, sir.
presentation. Keep
Thank you,
doing good
sir.
work.
Thank you, sir.
Thank you, Ashu.
Thank you.
Now I would like to call Sakshi to present her paper. Namaste, Honorable Chairperson Madam, Advisor CEO Sir, President in Charge, respected Dean Sir, and Director Madam, and respected guest speakers, all the faculty members, and my dear JVNs. I, JVN Sakshi Chaudhary, pursuing Masters of Business Administration with the stream of Banking and Finance second semester. As we know, today we are all gathered here for a national conference on analysis and development of arbitration and other of ADR in India. And my theme title is Role of Arbitration in Family Disputes. Never arbitrate. Arbitration allows a third party to determine your destiny. It is a resort of the weak. What is arbitration?
a process of resolving disputes between people or groups by referring them to a third party, either agreed upon by them or provided by law, who makes a decision. Arbitration is the private determination of a dispute by an independent third party. An arbitration hearing may involve the use of an individual arbitrator or a tribunal. Next slide is classification of arbitration. First is commercial arbitration. Commercial arbitration is a means of settling disputes by referring them to a neutral person, an arbitrator, selected by the parties for a decision based on the evidence and arguments presented to the tribunal. Second is consumer arbitration. Consumer arbitration surrounds between a consumer and a supplier of goods and services. Labor arbitration. Labor arbitration involves settlement of employment-related disputes. Next is rights arbitration. Rights arbitration, it deals with the allegation that an existing collective agreement has been misinterpreted. Various legislators requires that the parties who enter into a collective agreement set out a procedure for the handling of disputes and differences. And the last is interest arbitration. Interest arbitration is normally imposed statute and involves the terms and conditions of employment to be contained in a resulting collective agreements. Keeping your family together is an extraordinary feat, especially in the face of great conflict. Family dispute. Family dispute means a legal dispute arising out of a family relationship, including disputes concerning the welfare of children or which may give rise to family proceedings. Disagreements within a family are often one of the most challenging issues to manage and can leave a family fractured. Family breakdown involving divorce or separation related disputes are usually difficult. There are various ways of resolving family disputes, even the most challenging involving divorce and child related issues. Causes of family disputes. First is different parenting styles. Firstly, some parents have clear expectations, definite rules, and they are totally supportive to their children. Secondly, some parents have high expectations, they are well disciplined, plus they are unsupportive to their children. But sometimes they are also supportive in some situations. Thirdly, some parents are such types who doesn't make any boundaries for their children and also quite supportive. Next is power struggle between parents and children. As a parents want to protect their children and keep them safe. When children assert their independence, parents often fight to maintain their authority, causing communication to break down and leaving both parties feeling disrespected and misunderstood. Next is sibling rivalry. Sibling rivalry throughout childhood, siblings will compete whether for toys on their parents' attention. If one child has special needs or a more demanding temperament, this can make things even terrible. Siblings fight can be very stressful for parents who feel they can't win, so they leave to sort it out for themselves, causing children to feel even more frustrated and let down. Dealing with in laws. There are some key points to dealing with in laws. First is be united, build boundaries, treat them as you would like to be treated. Last is grandparents interference. Grandparents can play a wonderful, unique role in families, but conflicts can arise when they overstep their boundaries. If the grandparent in questions is an in-law, the situation become more volatile. Techniques of family disputes. First is try to calm. Try to put emotions aside. Don't interrupt the other person while they are speaking. Actively listen to what they are saying and what they mean. Check that you understand them by asking questions. Communicate your side of the story clearly and honestly.
No, for a minute.
Like
Shakshi, go to, I think your name is Shakshi, is that right?
Yes, sir.
Okay, go to the previous slide. Techniques of are these
Yes,
the techniques for family dispute, or are they the do's and don'ts?
sir, it's a techniques.
Okay, if these are the techniques, other experts are also here, our faculty members are also here. Tanushi madam, put your views. Are these the techniques or do's and don'ts? Because it's also our responsibility. Heading has been put by mistake to correct the students because they are here to learn.
Yes, sir.
So Sakshi now defend that these are the techniques because you are presenting, so you should know how to defend also. Simply say, beta, that sir, yes, there is a mistake in the heading. These are don'ts, do's and don'ts.
That we should do
Okay?
certain things and we
These
should
are
not
the
do certain
techniques.
things.
ये टेक्निक नहीं है, फैमिली डिस्प्यूट को का टेक्निक्स थोड़ा ही नहीं है. Tanushi, I would like you to share your views with the students and tell. Tanushi madam, tell her your observation that this. Do you agree, Sakshi?
Yes,
You
sir.
are not still. Why are you not agree? These are,
Sir, I'm not.
these techniques?
These are not the techniques. These are the
Yes,
things
it's so
that
simple. It happens a lot. We all are in digital world. कहीं का
in
इधर
layman
उधर
language we
हो
can say
जाता
that
है.
we can control our emotions. We should
Otherwise, your
be.
presentation was good. Everything was good. And if there is a mistake, it's not a big deal. It happens. It's very normal. But the biggest thing is just to accept it, say yes, sir, and move to the next slide and to the next sentence. Okay?
Yes, sir.
All right. What I noted, what I observed, I shared.
Any questions
Yes,
for her?
continue now. Don't be discouraged. Continue with the same spirit.
And my last slide is, when life gives you 100 reasons to cry, show life that you have 1,000 reasons to smile. Thank you.
And what was your topic? What was your title of the paper? Go on the first
Role
slide.
of arbitration in family disputes.
Role of arbitration in family disputes. Okay, all right. So you tell me one thing. Where can we find these arbitrators? I mean, suppose I have a problem. Suppose any individual have problem. So how to initiate this? Out of court and how to go to the arbitrator. Mediation we all know we can find. So कैसे करेंगे? क्योंकि whatever you all are telling, you should also know little practical implementation of these things. बताइए, whatever knowledge you have, you can share.
Sorry, sir, but I'm not from a law and I'm from management department, so
Okay,
I have
you are
more knowledge
from
about it.
management. All right. So you were supposed to take a topic related to dispute resolution or consumer court issues or consumer problems, how to resolve them through mediation and all that. Of some corporate house rather than picking a topic of core law and presenting that. Isn't it, Tanushi madam?
Yes, sir. But
So
she
it's
tried.
not her fault, actually, beta. It's not your fault, but still you tried. That's good. Okay. Thank you very much.
Thank you, sir.
Thank you, sir. Now I would like to invite Miss Vandana to present her paper.
Namaste. Good morning to all. Honorable Proprietor Sir, Dean Sir, Director Ma'am, respected teachers, and my dear friends. I, J.P. Banna, pursuing BLLB 8th semester. Today, I am going to present on the topic of recent development, emergency arbitrator, issue of confidentiality, appeal at Arbitral Tribunal. Introduction. In the trading and commercial world, each commercial activity is generally carried out through a contract and avoid legal disputes. Then after, there are a number of inevitable disputes before the court. According to data from the National Judicial Data Grid, at present, 3.9 cases are pending in district court, 58.5 lakh cases in various high courts and more than 69,000 cases in Supreme Courts. Therefore, to reduce the burden on the court, the proceeding called ADR, Alternate Dispute Resolution, was adopted by the judicial system. Because it was popularly said that justice delayed is justice denied and justice hurried is justice buried. So, the ADR is heartedly accepted as out of court settlement machinery. ADR's primary goal is to avoid vexation, expense, and delay, and to promote the idea of access to justice for all. The ADR system aims to provide definitions that are affordable, simple, fast, and accessible. This includes methods such as negotiation, mediation, conciliation, and arbitration. Now, I will take your attention to the development of ADR. Under the rule of East India Company, in the early and medieval times, the law was not codified and was regulated by social sanctions. The East India Company began to take control of the administrative powers. The presidential government of Bengal, Madras, and Bombay has adopted regulations into law. In Bengal Regulation 1772, a provision was made to submit all cases of disputed accounts and other matters to the arbitration for decision, and the award of the arbitrator was implemented as a decree of the court. Under the rule of British India, the legislative branch of India was enacted in 1834 by the Codified Act of 8, 1859, the Arbitration Act was incorporated into Chapter 6 of Act, Section 312 to 327, and it was replaced by the Act 10 of 1877, was superseded by Act 14 of 1882. Under the independent India, the Constitution of India, Article 51, Clause C and D provides that the state shall endeavour to foster respect for international law and treaty obligations in dealing with organized peoples with one another, encourage settlement of international dispute through arbitration. The Arbitration and Conciliation Act of 1996 abolished the Arbitration Act of 1940, the 1937 Arbitration, Protection and Confidentiality Act, and the 1961 Foreign Award, Recognition and Enforcement Act. This law covers both international arbitration as well as domestic arbitration and was based on the unilateral model law on the international commercial arbitration. The 2015 Arbitration and Commercial Amendment Act was subsequently passed with several amendments. After that, the Arbitration and Conciliation Amendment Act 2019 was enacted based on the recommendation of the committee. The Arbitration Council of India was established to promote ADR and increase arbitral bodies in arbitration in India. Objective of research paper. ADR option can be used in cases where litigation is not the most appropriate route. However, they can also be used in conjunction with litigation when the parties want to explore other options but also want to remain free to return to the traditional court process at any point. It gives confidentiality, flexibility of procedure, lower cost, less complexity, suitability for multi-party dispute, likelihood and others, and speed of settlement. I am taking this data from the secondary source of information, which includes these sites. Now I am describe about alternative dispute resolution and its techniques. There are 4 types of techniques: arbitration, mediation, conciliation, and negotiation. In arbitration, there is an impartial third party called an arbitrator needed. In mediation, an impartial and neutral third party called mediator is needed. In conciliation, impartial and third party called conciliator needed. In negotiation, there is no need for third party. A case, Guru Nanak Foundation versus Ratan Singh and Sons 1981. In this case, they stated that they saw the Arbitration Act of 1914 as an alternative means to less formal, more efficient, and expeditious settlement of disputes. However, some modifications are required so to meet the need of the present time. Arbitration and Conciliation Act 1996. Arbitration is an alternative dispute resolution mechanism in which parties refer the dispute to arbitration depending on whether there is an agreement called arbitration agreement that the parties have entered into as a separate agreement or they enter an arbitration clause in the main contract. A case, Wellington Association Limited versus Kirti Mehta 2000. Supreme Court has determined that the arbitration clause defined when a dispute arises either to initiate arbitration or go to the court. These lines are included in the contract but do not indicate the intention of the parties. The Arbitration and Conciliation Act is primarily based on unilateral model law, enacted to integrate laws relating to enforcement of domestic arbitration, international commercial arbitration, and foreign arbitral awards. Emergency arbitrator. Emergency arbitrator, distinguished as emergency assistance, is a new concept in the field of arbitration and is suitable for anyone who wants to protect assets or evidence that could otherwise be modified or lost. Such arbitration is usually agreed upon and arranged by the parties themselves without resorting to the court of the first instance. issue of confidentiality, in 2017, a high level committee was established to consider the institutionalization of the arbitration mechanism in India and to propose changes in the introduction of the principle of confidentiality in arbitration proceedings. For this reason, a 2019 Arbitration and Conciliation Act was amended in 2019 and enacted in Section 42A. Section 42A, confidentiality of the information, the arbitrator. The arbitral bodies and the parties to the arbitral agreement will maintain the confidentiality of all arbitral proceedings except the arbitral award if the disclosure is required for the implementation and enforcement of the arbitral award. Arbitral Tribunal, according to Section 2(1)(d) of the Act of Arbitration Conciliation in 1996, determined by Arbitral Tribunal, refer to an arbitrator or arbitral panel. It determines Chapter 3 under Section 10 of the Act. An arbitral tribunal is discharged by the functions of quasi-judicial nature on the principle of natural justice and fair game, but this is not a court. The award of the arbitrator has the same effect as the court order. It binds the parties. Article 323 of the Constitution of India provides an establishment of a tribunal to deal with other specific issues. This article also authorizes legislature and state legislatures to establish the tribunals to address matters other than those outlined in Article 323 of the Constitution. This also helps in development of arbitration proceedings. At last, I am conclude my paper. By studying this work, you will find out the mechanism that you justify accessibility for everyone. They can deliver it quickly, simple, and easy. The Arbitration and Conciliation Act of 1996 expanded its scope through occasional amendments by law to strengthen domestic and international arbitration. These changes and evolution in ADR may provide a futuristic aspect by the simple steps as defined in Part 1 of the Arbitration Conciliation Act. The law also expanded its scope by aligning the amendments made in 1996 with members of International Convention with the Unified Model Act. Commercial disputes include the confidentiality of their business and proprietary secrets that have been fully respected in arbitration and conciliation. Section 19 of the Act states that the parties are free to agree on the procedure that the arbitration court decides during the procedure. This means this helped during the pandemic period when the Arbitration Council of India defines that these arbitrary agencies are required to conduct offline or via video conferencing. Thank you.
Thank you, Vandana. Any questions for her?
वतना बड़ा
Yes,
बेसिक
ma'am.
क्वेश्चन है थोड़ा इसमें फोकस डालो कि व्हाट इज द डिफरेंस मतलब बिटवीन कमर्शियल आर्बिट्रेशन और इंटरनेशनल कमर्शियल आर्बिट्रेशन
Commercial arbitration है, international
एंड
commercial
इंटरनेशनल
arbitration.
कमर्शियल
मैम जैसे कमर्शियल आर्बिट्रेशन अगर मतलब डोमेस्टिक और इंटरनेशनल में अगर कंपैरिजन करते हैं तो डोमेस्टिक मतलब इनसाइड द कंट्री टेरिटरी ऑफ इंडिया में जितने केसेस होते हैं. अगर इंटरनेशनल की बात करें जैसे हम यूनिसेटल मॉडल लॉ से हमने अपना एक्ट बनाया है क्योंकि हमारा आर्बिट्रेशन सबसे पहले यूएसए में आया तो वहाँ के बेसिस पे हमने अपना आर्बिट्रेशन एक्ट बनाया, उसकी बेसिस पे हमने चेंजेस डाले. तो जैसे कोई बाहर का केस मतलब बाहर की पार्टी एक इन्वॉल्व होती है, एक इंडियन पार्टी इन्वॉल्व होती है,
यू
तो
नीड टू
उस
से वन पार्टी इज फॉरेनर
यस मैम
आउट ऑफ
फॉरेनर
इंडिया
वन फ्रॉम डोमेस्टिक कंट्री. तो उस केस को रिजॉल्व करने के लिए हमें इंटरनेशनल अवार्ड को इन्फोर्समेंट लाना पड़ा, जो रिकॉग्निशन एक्ट जो पहले था जिसको अबोलिश करके यूनिसेटल मॉडल से हमने कंबाइन किया. तो उस लॉ को मिला के ये मतलब अगर दो पार्टी डोमेस्टिक कंट्री से इन्वॉल्व करती हैं तो हम डोमेस्टिक
कमर्शियल
यस मैम और बाकी इंटरनेशनल आर्बिट्रेशन.
इंटरनेशनल कमर्शियल आर्बिट्रेशन.
Okay, Vandana, can you?
एक्चुअल में इसी से जुड़ा हुआ एक और क्वेश्चन मतलब डिफरेंस बिटवीन फॉरेन अवार्ड एंड अवार्ड सिंपल अवार्ड एंड व्हाट इज द डिफरेंस बिटवीन फॉरेन अवार्ड एंड अवार्ड.
मैम अगर फॉरेन मतलब फॉरेन अवार्ड मींस अगर पार्टीज फॉरेन पार्टी इन्वॉल्व करती है और वो यूनिसेटल मॉडल लॉ और इंडियन आर्बिट्रेशन एक्ट से इंक्लूड कर रहा है तो फॉरेन अवार्ड उसको टर्म किया जाएगा. सिंपल अवार्ड जो जैसे अगर यहाँ की डोमेस्टिक कंपनी की पार्टी इन्वॉल्व कर रही है तो अवार्ड सिंपल ये भी हो सकता है या फिर सीबीसी में जो भी अवार्ड दिए जाते हैं उसे भी अवार्ड डीम कर सकते हैं.
Okay. Navtika ma'am, your question?
Okay, Vandana, wonderful presentation, full of information. I have a question. Can you go to your first slide?
Yes, ma'am.
You have mentioned two things: justice delayed, justice denied, and justice hurried and justice buried.
Yes, ma'am.
Both of them are completely
And
opposite to each other. Can you enlighten me that, okay, did we left her? She's not in the Tanushri ma'am. I think we lost her connection.
I think she should be back because the question is really good. Uh, yeah. So see, because of what I think that's the motive of this conference. If these students are coming on the dais, they are presenting, they should also be able to defend or
Absolutely,
be
sir.
logical, or if it is wrong, then they should have the courage to say, at least at this stage, they're very young, to say that, yes, it's my mistake and I accept it. That's the biggest thing. And if they have written something, then defend. It's so simple.
It's
So
okay.
call her, Tanushi madam. Where is she gone?
You are mute, Tanushri ma'am.
Thank you, ma'am.
Yeah.
Please here just a second. I'm connecting her.
yes, ma'am.
Yeah, Tanushri. In your first slide, you have mentioned two quotes: justice delayed is justice denied, and justice hurried and justice buried.
Yes, ma'am.
What do you mean by these two lines? Because they're completely opposite to each other.
Yes, ma'am. Ma'am, justice is delayed is justice denied. I mentioned that line because in ADR the procedure are मतलब स्पीडी प्रोसीजर होता है, और जैसे बाकी कोर्ट्स की बात करें तो 1 साल 3 साल 4 साल मतलब डिलेड होता रहता है, और तो इसके लिए मैंने मतलब ये वाला कोटे लिया, और हरिड और बरिड मैम इसलिए यूज किया कि मतलब जैसे अगर हम बोले कि स्पीडी ट्रायल में अगर किसी केस को ट्रायल में ले जाए और एविडेंस और इसके अगर नहीं मिल पाता है, जैसे स्पीडी ट्रायल में 3 to 6 months में अगर जल्दी स्पीड करवाना है किसी केस को, तो वो लोग कुछ एविडेंसेस को अगर इग्नोर करें बाई चांस और अपने उस पर डिसीजन पे पहुंच जाए, तो इसकी वजह से।
Okay, you cannot make us fool. We are experienced people. If you're not able to answer, you can excuse yourself, no problem, because of the excitement, because these two quotes excited us, we put it here. I want to give suggestion to each one of you, your classmates also, you can share that write in bullet point whenever you
Yes.
want to write in PPT. Give in bullet points. If you have referred my presentation which I have presented, there was bullet points. Okay, so if these two lines were in bullet points, you can explain that, ma'am, in traditional court setup, we have justice delayed because of the time taking process. That's why we can say that justice denied. But in ADR, it shall not be even justice hurried, so that it will not be a justice buried. In this, I got what you want to say, but when you will explain, you have to explain in this manner, to make it in so hurry in ADR. Let's not forget the mechanism, the basic principle of justice, basic principle of legal justice system. So this could be the real time explanation,
Yes.
but you use in one paragraph both the lines. So I got confused that what you mean to
Justice
say.
is
So
a part of
And
alternate
Dr. Navtika is right.
alternate
Always the
resolution है.
PPT must be in bulleted form. We have told them, and the student also know. But what happens in a hurry to take a shortcut and all that, just paste it, we'll read it out. Because I am saying it very clearly. There is nothing to hide. At least at this level, they know. But just to be in a comfortable zone, and sincerely, you should follow the, as told by Dr. Navtika Singh. We always tell you, put it in bullet form, read that bullet, explain it in your own words. So that is expected from you. So next
Yes, ma'am.
time, whenever you do presentation anywhere, do it in bulleted form, and you will get a great satisfaction when your presentation will be over. You will feel so confident that look, I am speaking just by taking 2 words, I am speaking for 15 minutes. And that is the basic motive of all these conferencing, getting together, disseminating the knowledge. So very well said, Dr. Nartika, and all of the presenters, they should follow these things. Thank you very much.
Yes, sir.
Okay, thank you all the guests. So this is our lunch time. We have lunch time from 12:45 to 1:30. Hope so we meet at 1:30 soon.
Yeah, we kindly start the next session sharp at 1:30 because it is
Sure,
to
sir.
be end at 3 p.m. After 3 p.m. there will be face-to-face certificate distributions in Rekha Govil Sabhagar today.
Sure, sir.
And we
Okay.
have to select the, that one winner also. So that's it. Thank you.
Okay, sir. Okay, ma'am, you can go for lunch. Sir, it's 1:30. Should we start? Sir, should we start? Pro President Sir, Naptika Ma'am, Dean Sir, should we start?
Um, from my end, you can start.
Dean Sir, Pro President Sir. Ma'am, we are starting because we have number of students and we need to finish till 3 p.m. Okay, ma'am?
How many presentations more are there?
There are like 10, 12 more presentations. So I think we should start,
Okay,
otherwise
please
it will
start.
be
Yeah,
late.
yeah.
Okay, okay, thank you so much. Now I would like to invite Akshita and Komal to present their paper. Share screen first. The PPT is not showing. You see how the sharing screen is not on. Now this browser is brown. Browser screen. Actually, the browser has blocked the screen. We need to wait for 1 minute.
Good afternoon to all the higher authorities, our respected guest, Dr. Navdika, ma'am, our Dean Sir, Pro President, and all the JVs. Welcome here. I, Akshita Sharma, pursuing BB LLB 5th semester, 5th year, here presenting a presentation of the topic Basic Introduction to Alternative Dispute Resolution. Myself, JVM Komal Daima, to represent the presentation post topic of Basic Introduction of ADR. Let's start introduction. Today's world has become globalized and commercial with the advent of technology. People can now contact each other and settle businesses, deals and disputes when they are
when they are in sitting at the opposite end of the world. Most people no longer have to fill papers and the court and then wait long period of hearing. We are rapidly approaching a stage where litigation is being replaced with alternative dispute resolution, that is ADR. Due to the inefficiency and drawbacks of litigation, India has not quite reached a stage where the litigation has completely displaced by ADR method. But the legal system is beginning to see the benefits of ADR. The articles shall be helpful to give you overview of ADR methods and how it beneficial. Let's start. What is alternative dispute resolution? ADR refers to range of dispute settlement methods which help the party in dispute to come to settle without going to court or without litigating on said matters. These methods usually involve a third party who helps them in settling a dispute. In many cases, ADR methods are used alongside the litigation process as well as through the court authorization.
How did the concept of ADR arise? As stated in the 22nd report of the Law Commission of India, the Constitution has guaranteed access to justice for all, primarily through Article 19A, 39A, which states that everyone must have an equal opportunity of getting justice and this must not be denied to any citizen by reason of economic or other sort of disabilities. The report further states that access to justice for the common masses in India means access to the courts by of law. But even that has been hindered due to factors like poverty, illiteracy, ignorance, social and political backwardness, etc. In a developing country like India, many people still live in poverty. When their rights get violated, they often do not have the money to fight long battles in the court. They do not have the money to afford a lawyer. They do not know the legal system and procedures. Therefore, they often think that the court system is an inconvenience. These kinds of inefficiencies are shared reason among many countries, which is why ADR is being explored. The courts also have too many pending cases, and these cases keep going on for many years, which is tremendous burden to the court. These reasons prompted the Indian government to enact Section 89 of the Code of Civil Procedure 1908 and replace the earlier Arbitration Act 1940 with the Arbitration Act 1996 in accordance with the mandates of the United Nations Commissions on International Trade Law. The pros of ADR are cost saving, speed control, confidentiality, experience neutral panelists, cooperative approach, flexibility, parties into good terms. And the cons of the ADR are unequal bargaining power, lack of legal proficiency, no system of specific model, enforceability required, court actions might not be a good fit, limits discovery process. The types of ADR methods include arbitration, mediation, negotiation, and conciliation.
I will conclude my PPT. There are many other disputes resolution methods like mid-arm, mid-trials, summary jury trials, etc. But arbitration, mediation, and lok adalats, etc. are the most commonly used techniques of ADR in India. Throughout the world, ADR has been slowly become a favorable choice of parties, but India still relies a lot on litigations. However, with the development of these ADR methods and efforts of improving access to justice, ADR is being to see as the necessity. Legal recognition should be given to all ADR methods, including negotiation, as they are visible and convenient, and it would help to reduce the burden of the court.
Thank you.
Thank you.
Thank you, Akshita and Komal.
What's your name? The presenters.
Any
अपना
questions for
नाम
them?
बताइए. Am I audible to you?
Yes, sir.
आपने अपने नाम बताइए. Both of you tell your names.
Your name?
So I, Akshita Sharma, pursuing BB LLB 10th semester.
Myself, Komal Daima, pursuing BCom LLB final year.
So, JV, Akshita, and Komal, you tell me how your this presentation is different than the previous one. Did you see the
Sorry, sir, we didn't
previous
get you.
presentation? पहले वाला presentation. Did you see the previous presentation? पहले वाला presentation देखा था आपने?
Sorry, sir, last two presentation we haven't got that.
Okay, you don't know. All right. Then can you elaborate the step-by-step process of mediation, which is the simplest form? Tell me how it will be done.
What is
Sir, kindly repeat.
मीडिएशन कैसे होता है?
Mediation.
Step by step process of doing the mediation.
Okay. Sir is asking step-by-step process of mediation.
मीडिएटर एजेंसी, मीडिएशन एजेंसी होगी, वो क्या करेगी, कैसे करेगी? टू पर्सन्स आर अप्रोचिंग फॉर द मीडिएशन, हाउ इट विल बी डन?
Okay. Okay. Thank you, sir, for question.
आपने
According
बताया
to
ना
this,
चार टाइप्स हैं अपनी स्लाइड में, मीडिएशन है, कॉन्सिलेशन है, आर्बिट्रेशन है.
yes, sir, yes, sir.
So how it will be done? That simple thing I am asking.
Okay, sir. Sir, according to ADR, a neutral person, the mediator assists the parties to reach the compromises. The job of the mediator is to consult with each parties and see how which common ground and interest there in between them. It means that the mediator firstly talk with parties and talk about the issues, and after that providing solution to both the parties and listen both the parties issues, and then provided the solution.
that basically focuses on determines the interest of the parties. It only sees that the interest of the parties on what ground it could be sorted.
And then how it will be finalized? There is a one important step, the last step. देखिए,
Sorry,
आप
sir.
अगर लॉयर हैं और आप लॉयरशिप नहीं कर पाते हैं, तो मुझे नहीं लगता कि देयर इज बेनिफिट ऑफ योर, स्पेशली इन लॉ. मैं एक वर्ड सुनना चाह रहा हूं कि दोनों उसको साइन करेंगे, दैट्स इट. बहुत सिंपल सी चीज थी.
Yes, sir.
अगर वो बोथ पार्टीज आर नॉट साइनिंग इट, देन देयर इज नो मीनिंग ऑफ दैट.
Yes, sir. Both the parties both agree, then
हाँ,
yes.
तो मैंने भी आंसर भी बता दिया आपको, क्वेश्चन भी पूछा आपसे ही. So be attentive when the question is being asked, and you should have the courage, like you show the courage. तो मैंने पूछा था लास्ट चीज क्या होगी, तो you were supposed to answer कि सर that will be signed by both the parties and it is done. ठीक है. अब हमारे लवतिका मैम है, वो सी के लास्ट and take it further if you have any question.
Thank you so much. In the conclusion, Komal, you have mentioned about the Lok Adalat. This is something new word from the morning. We have not heard it. So can you put light on the word Lok Adalat? What do you mean by Lok Adalat?
मैम जनरली लोक अदालत मैम जो विलेजेस पे मोस्टली फोकस रखता है. जो पुअर पर्सन्स होते हैं वो मतलब कोर्ट्स तक जा नहीं पाते, तो उनके लिए एक लोक अदालत स्टैब्लिश की जाती है एडीआर के थ्रू, ताकि उनको भी जस्टिस प्रोवाइड हो सके. और yes, ma'am.
No, dear, I'm really sorry. This is not the right answer for Lok Adalat. Go sit back and read about Lok Adalat. It is not the answer. I'm really sorry to say. Because Lok Adalat could be for cities. It is only for the speedy trial. Okay. Even there are mega Lok Adalats, the cases, the petty offenses till 5 years of imprisonment or very less fine. For example, traffic cases. To solve them, quickly without proper trial, the courts which has been there are called as Lok Adalat. They are the speedy trial courts. Okay. So before mentioning anything, it's my request that you have to read about it.
Okay, ma'am. Sorry, ma'am.
Okay. Thank you, Akshata and Komal. Now I would like to call Prerna Shri for her presentation.
Namaste, respected Chairperson Ma'am, Advisor Sir, Dean Sir, President Sir, all the guest members, faculty members, and all my dear JVNs. I, JVN Prerna Shri, pursuing MBA in Agribusiness Management from Jayoti Vidyapeeth Women's University.
And I am Pooja Kiran, pursuing BSc Agriculture, MBA in Agribusiness Management in 10th semester.
I, Chairman Asu Kumar, from BSc Agriculture plus MBA plus from Jyoti Vidyapeeth Women's University.
Myself, Kalpana Chaudhary, I am pursuing MBA again.
Our topic is a study on the performance of regional rural banks in India. Let's come to the introduction of our topic. Regional rural banks are government-owned scheduled commercial banks of India that operate at regional level in different states of India. They were created to serve rural areas with basic banking and financial services. It was founded on 2nd October 1975. Regional rural banks are banks formed in collaboration by the central government, state government, and sponsoring commercial banks to give loans to rural areas. Their mission was to fulfill the credit needs of the relatively unserved sections in the rural areas, small and marginal farmers, agricultural laborers, and socio-economically weaker sections. Now, next topic will be delivered by Pooja Kiran.
Namaste. Let's come to objective of our topic. First, to study the need of banking in rural areas. Second, the function of RRBs in rural development, the financial performance of RRBs. To study the challenges faced by the banking in rural areas. And fourth is to study the possible solution of the problem faced by the rural banks in rural areas. To provide advantage to small and marginal farmers, agricultural laborers, to provide banking facilities to rural areas, especially unbanked areas. And next is to provide loan facilities to cooperative societies which are engaged on services related to rural areas, including agriculture activities. The last one is to increase the golden opportunity of employment in RRBs, which creates employment at their doorstep for rural people. And next slide is presented by Alpna Chaudhary.
Sources of data and methodology. This paper is based on the secondary data and obtained from annual reports of NABA and from various reports and websites. Highlights. Regional rural banks came into existence for providing the credit facilities to the small and marginal farmers, agricultural laborers, artisans, and small entrepreneurs for the agricultural trade, commercial, and other private productive activities. Initially starting with the 5 RLBs at Muradabad and Gorakhpur in Uttar Pradesh, Jaipur and Rajasthan, Haryana and West Bengal on 2nd October 1975. The RRBs achieved a phenomenal growth over the years. As on 31st
थोड़ा
March
थोड़ा लाउडली बोलिए और
56,
थोड़ा रुक रुक के पढ़िए
number
उसको.
covering 680 notified districts in 27 states. At the Union Territories of
Excuse
Pondicherry,
me.
a network of 21,422 branches.
थोड़ा सा आप इसको प्रेजेंटेशन की तरह प्रेजेंट करिए. If you are reading, तो इतना तो स्लो, थोड़ा ऐसा पढ़िए कि so that read like that so that listeners can understand. Yes, start from beginning. Initially starting with 5 RRBs. यहाँ से start करिए. नहीं, उसी स्लाइड में यहाँ से, हाँ यहाँ से करिए.
Initially started with 5 RRBs at Muradabad and Gorakhpur in Uttar Pradesh, Jaipur and Rajasthan, Haryana and Western Bengal on 2nd October 1975. The RRBs achieved 8 phenomenal growth over the year. As at 31st March 2017, they are 56 in number, covering 680 notified districts in 27 states and the Union Territories of Pondicherry, with a network of 21,422 branches. Rural household also needed funds from carrying out their agriculture activities. For meeting credit needs, they approach to money lenders because loan from the financial institution involves a lot of paperwork, formalities, and also time consuming. Next slide present by Masu.
Problems of regional rural banks. RRB plays the important role in developing the weaker section in rural areas of our society. Along with the RRB face serious problem. Huge branch expansion as at the earliest stage of RRB evolution. A large network of branches opened which creates problem of overhead cost without contributing an amount of profit. High cost of loan with comparison to commercial bank. RRB have the high loan transaction cost than the commercial bank due to low amount of loan. Problem in deposit mobilization as RRB deals with the weaker section of rural areas. There is no huge amount of funds in bank. The weaker section in the main target of RRB are poor, so they don't save so much money in RRB. It provides less amount of collection in banks. No proper requirement policy as RRB are rural oriented. They are expected to require staff only locally. But with the transfer of recruitment on RRH to banking service, recruitment boards all the continent outside the area of cooperation of RRH eligible for RRH. This is against the concept of RRH. In some areas where RRHs are required, they face difficulty to get full accommodation or facilities for homes with the branches. Then last topic conclusion. The regional rural banks have been highly successful in the mobilizing rural savings. RRBs are providing loans to small and marginal farmers, artisans, self-employed person etc. RRBs recruit local person which create the employment at the doorstep of rural peoples. Thank you.
Thank you, students. Any questions for them?
Yes, ma'am. See, plain reading of your PPT is not presentation. So it's again a request to each one of you that you have to have very less content on your PPT. Second, while you have presented your concept, can you define me the objective of your paper? What is the title of your paper? Can you please tell me?
Rural.
A study of performance of regional rural bank in India.
So in this, there must be few objectives on which you must be writing your paper.
Yes, ma'am.
Objectives
So
are
what are the objectives?
To study
To study.
to study the financial aspects of rural areas and many more.
What else?
Basically, regional rural bank helps rural area people to give loans so that they can perform their agricultural sector properly,
See,
and they provide credit to
my
them.
my point for questioning you guys is you have prepared a presentation, but you have not even bothered to understand your objectives. Getting my point? So,
Yes, ma'am.
students, whenever you are making a presentation, at least there are few things which you have to keep in mind, and objectives are one thing. Without opening the slide, you were not able to make me understand, ma'am. These are the gray areas on which we have had our presentation. Nevertheless, no problem. You will learn gradually. So, all the best. We can move ahead with second presentation if others don't have a question.
Thank you.
Thank you, students. Now I would like to call Sherry Verma to present her paper.
Namaste to Proctor Sir, Dean Sir, Director Ma'am, and all the respected dignitaries and my worthy friends watching out there. I, Jivan Charlie Verma, pursuing BA LLB, fourth year, and I am here in front of you going to present the topic development development of arbitration and its role in family disputes.
Just a
दो
second,
बजे
she's just
दो
sharing.
आधे घंटे में दो हो रहे हैं.
Now the introduction. India is the second populated country, therefore, there is a trend of increasing disputes. Hence, multiple cases of civil natures are pending before Indian courts. At the same time, people have not much time to go and file the case and wait for the judgment. There, because justice delayed is justice denied, and also not everyone can afford litigation. Our country is entering into a stage where court litigation is being replaced by an alternate dispute resolution. ADRs are those resolutions which don't need a trial. It is basically out of court settlement. They are used for disagreeing parties to settle their disputes with the help of third parties. ADR methods are arbitration, conciliation, and mediation. Arbitration is that form of settlement in which disputes is referred to the arbitral tribunal in which further give arbitral award binding on the parties. Conciliation is that formal resolution in which is a less formal form of arbitration having no binding procedure. The conciliator helps the party to come on mutually satisfactory and an agreed settlement. Negotiation is a peaceful dispute resolution, a non-binding procedure again, where the party directly approach the other with the offer of negotiated settlement of disputes. Mediation is also non-binding procedure in which the impartial third party mediator assists the party in reaching the mutual agreement. Now, the international development of arbitration. The United Nations Commission on International Trade Law, UNICITRAL, the General Assembly of UNO through its resolution 200 121 established UNICITRAL on December 17, 1966. The Commission discussed the commercial arbitration has produced draft and later adopted it, such as UNICITRAL arbitration rules and UNICITRAL model law on international commercial arbitration. Model law on international commercial arbitration of UNICITRAL, it applies to international commercial arbitration and subject to any agreement in force between this state and any other state. Unilateral Arbitration Rules 1976. The Commission adopted the rules contained in the settlement of dispute. Now, the development of arbitration in India. In ancient times, arbitration has been prevailing from Vedic times in India. Sage Yajnavalkya mentioned three types of court, that is, Yuga, the local courts, Shrenis, people engaged in the same business, Kulas, the particular community member relating to social matters. Secondly, the panchayat are the systems where the disputes are solved by wise men of society and their decisions are binding on party. And under the rule of East India Company, Bengal Resolution of 1772. Under the rule of British India, first law on arbitration in India was introduced in 1899. The Indian Arbitration Act 1899 was applicable only to the presidency towns of Madras, Bombay, and Calcutta. This act was very complex, bulky, and need to reform. As a result, a more specific, the Arbitration Act came into force in 1940, but had a major drawbacks like more interference of court. So the government decided to review the Arbitration Act 1940, and the Arbitration and the Conciliation Act 1996 was introduced and repealed all the former acts. Now, arbitration in family disputes means to decide the matter out of the court. Such disputes includes all the matter which come under a family, such as issues among wife and husband, marriages, divorce, maintenance, etc. of they need to share it with a third party who will try to solve and come to a conclusion. The parties opt for the dispute to be resolved in a private manner with no involvement of court proceedings. Now, why to opt arbitration in family dispute? Because it is a choice of arbitrator. Efficacy, less costlier, privacy, flexible remedies, outcomes is binding on the parties as same as the court. Now, the Indian laws on the family dispute arbitration. Arbitration under the Arbitration and Conciliation Act 1996. Lok Adalat under the Legal Service Authority Act 1987. Family Court in the settlement under the Family Court Act 1984. CPC Section 89 and Order 32A6 and Section 23 of Hindu Marriage Act 1955. Now the case laws. Baljinder Kaur versus Harshdeep Kaur. The parties filed a petition before a court for divorce. Court, before granting the divorce, attempted reconciliation between parties, stating that reconciliation as a form of alternate resolution of dispute is mandatory in divorce proceedings. The court emphasis should be on bringing parties to a mutual agreement. Now, I would like to conclude. In case of Jagraj Singh versus Birpal Kaur, Supreme Court says the slogan for the day should be arbitrate, do not litigate. Thus, although not mandatory, giving alternate mode of dispute resolution a chance in resolution of matter in the norm of Indian legal system. Raising disputes indicates towards the lack of awareness of A.D.R techniques. Much more awareness needs to be made in the public. Marriage is considered as a sacred institution which must be preserved. Hence, A.D.R method help them preserve relationship. India still needs to promote A.D.R and reform must be made. Thank you.
Thank you for your presentation, dear.
Any
Uh,
questions?
may I?
Sure, ma'am.
Yeah. So you have in your second last slide you have said that Supreme Court has said that do not litigate but mediate or arbitrate.
Yes, ma'am.
So do you also agree with this line?
Yes, ma'am, I agree.
How and why?
Ma'am, because in family disputes, arbitration used to do to come to a settlement, mutually agreed settlement. But in litigation, the parties like advocates used to do advocacy on the other's behalf. But in arbitration, in A.D.R's methods, we try to settle the disputes on a mutually settlement or decision.
Okay. Okay. Thank you.
Thank you, ma'am. Now I want to invite Pallavi to present her paper. Good afternoon, Honorable Pro-President in charge, sir, respected Dean, sir, respected Director, ma'am, and respected guest speakers, and all my faculty members, and my dear JVN. I, JVN Pallavi Singh Baswani, pursuing Bachelor of Commerce from the Department of Management and Commerce and Faculty of Law and Governance. First of all, I want to thank to my teachers who gave me this opportunity to give a presentation in front of you. Today, I am going to deliver a presentation on on the topic of role of mediation in a consumer dispute. Firstly, it is important to understand what is the mediation and by whom is this process is done. Okay, mediation is a process wherein the parties meet with a mutually selected, impartial, and neutral person who assists them in the negotiation and in the negotiation of their differences. And it is a informal process where trained mediator and neutral person, third party, assist parties in a resolution of their disputes. And so next is the who is the mediator who perform this process of mediation. Mediator is perform this process, and mediator is a person who help to settle a dispute or create agreement when there are conflicts between two parties or two persons. And next, move on to the next slide. That is the objective of the mediation. What is the objective of the mediation? Why we are selecting this process, and what is the main aim of this process? It's the main aim. This process is to reduce obstacle to communicate between two participants, and it helps to avoid an unnecessary cost to participants, and it reduce the time of two participants and promote good relationship between the participants. And its main aim to assist participant to reach the decision they consider appropriate to their own particular circumstances. And next slide is benefits of the mediation. Why we are choosing a mediation process? We Why we are not going to the further referral courts? We are only choosing a mediation process. So the benefits of the mediation is first main mediation benefit of the mediation is to reduce the time of two parties. As we know that in nowadays in everybody is busy in their professional life, personal life. Everybody has a lack of time, and they are busy in own life. So it reduces the time of a person. It provides a better way to resolve their conflicts, to resolve their problems. So it is helpful in reducing the time, and both parties can avoid the complexity of the civil procedure. As you know that the procedure of the court going through for a court, it is very long process. So we are choosing as a mediation process, and mediation provide a flexibility. It allows according to the need of the both parties. It allows both parties to choose their to decide their to resolve their conflicts. And one thing is that the mediator cannot be judgmental. Mediator never judged both parties. They can advise them. Only they can give a advice to both parties, but cannot be judgmental. Mediator cannot be compared. In it also, their work is role of mediation is only solving the conflicts, but cannot judge, cannot compel. Okay. The next thing is a
Next slide is the limitation of the mediation. What is the limitation of the mediation? If something has an advantage, so it is obvious has a disadvantage also. So it can be a bias, it could be no fixed rule, imbalance of the power between the parties, cultural problem, lack of legal protection of the parties. Uh, so as I said, it could be biased. Mediator could be biased because if two parties are there if there is a two parties and they are fighting for a one thing, so they mutually selected a mediator, but party A already known the mediator. So mediator could be biased because he and she already know party A. So it could be biased, and there is no fixed rule. Because there is no legal protection and there is no legal formalities. So it could be biased. It could no rule. So next, move on to the next slide, that is consumer dispute resolution through mediation under Consumer Protection Act 1986. It is old act and new act is enacted 2019. As you are aware that Consumer Protection Act 2019 is serving consumer fraternity since last 3 decades. This act has been promulgated to protect the interests of consumer from unfair trade practices and fraudulent trade practices adopted by the market players. And there are three types of consumer redressal forum, as a district level, state level forum, and the national level forum. One question is that why enacted Consumer Protection Act 2019? Consumer Protection Act also right. Consumer Protection Act 1986 is also right. So main thing is that Consumer Protection Act 1986 is narrowed in scope. So there was a changes in Consumer Protection Act 2019. There are three big changes in Consumer Protection Act. Mm, First is sorry, Consumer Protection Act change in 2019 changes the district forum rupee level. As a district, if any consumer have a problem with sorry, if consumer have a problem with any seller, any manufacturer, they can appeal in a district level court, with not exceeding 10 crore, no, sorry, not exceeding 20 crore, and then state level not exceeding 1 crore, and state level, sorry, national level not exceeding above the 1 crore. And next slide is conclusion. In the end, I have to conclude that this is the shortest, simple, less expensive, and the fast way. This is voluntary resolution. In this present scenario, we can use this as an online. We have completion of the mediation with the time limit permitted under the act in 30 days. Thank you.
Okay. Thank you, Palani.
If you have any queries and question, and you may ask.
Any query? Or should we proceed with the next presenter? Sir, ma'am, any query? Or should I proceed with next presenter? Because we have many more.
No, ma'am. Due to paucity of time, you please proceed. And if we'll have any specific query, I'll ask.
Sure, ma'am. Thank you, sir.
Yeah, please.
Thank you, ma'am.
Now I would like to invite Tanushree Nayak to present her report.
College Degrees. I, Javian Tanushree Kumar, pursuing BCom LLB at Samastipur, and I am going to present my topic, role of mediation in consumer dispute and resolution. Introduction. The term mediation can be defined as a voluntary dispute resolution process where the third party facilitate negotiation between the disputed party to negotiate for their rights and interests by themselves. The third party who facilitates the negotiation between the disputed parties is called mediator. In neutral person called mediator helps the party try to reach a mutually acceptable resolution of dispute. Concept of mediation. Mediation consists of negotiation between disputing parties assisted by a neutral third party, and it is defined as an intervention into a dispute or negotiation by an acceptable partial and neutral third party. Mutually accepted settlement of issue in dispute. Now, who is consumer? As per Consumer Protection Act 2019, the expression buys and goods and hires or uh, avails many services include offline or online transaction through electronic mean or by teleshopping, a direct selling or multi-level marketing. What consumer rights are granted under Consumer Protection Act 2019? Consumer is having the following rights under the Act: right to safety, right to be informed, right to choose, right to hurt, right to seek redressal, right to consumer awareness. Types of mediation. There are two types of mediation: court referred mediation, private mediation. Court referred a mediator to parties after filing case into the consumer court under section 89 of the Code of Civil Procedure 1908 under the referred mediation is post litigation mediation. As in case of Consumer Protection Act 2019, wherein section 37, 49 and 59 empowers the Consumer Commission to refer the case to the mediation cells attached to it. The private mediation is one where qualified media offers the services of mediation on a private fee or service basis to the court. Two members of the public, members of the commercial sector, and also governmental sector to resolve dispute through mediation. Private mediation can be used in connection with dispute pending in court and pre-litigation disputes. Now, advantage of mediation. Voluntary process, control of parties, active participation of parties, cost and time efficient, convenient to the parties, ensures fair process confidentiality, final settlement of the dispute in full. Time limit for filing the complaint. The complaint shall be filed within 2 years from the date on which the course of action has arisen. Now I'm going to conclude. Government notified some new rule for Consumer Commission which lays to enhance national body reduction and fast disposal of cases. Businesses are still trying to earn exploitation of consumers is the need of the her of for the SPD and efficient disposal of consumer cases, and it's commendable looking at the way of the government has a clear plan to employ mediators who can solve disputed by adding less burden of judiciary. On the other hand, mediation also create an alternative source of revenue for the people who can make also use it as an alternative source of income, and it's therefore welcome steps towards the roster of jobs in recent time of uncertainty. Thank you.
Thank you, Tanushri. Now I would like to call Manisha. Now I would like to call Ms. Garima to present her paper. May I start? Namaste one and all. Here I Garima Jat pursuing BA LLB 8th semester. When can I start? Start. Namaste one and all. Here I Garima Jat pursuing BA LLB 8th semester. As my topic is role of arbitration in family disputes. Introduction. Alternative dispute resolution, in short term it means to be ADR, refers to any procedure outside the court agreed to by the parties of a dispute in which they make use of services of neutral third party to assist them. Arbitration. Arbitration of family law means when a husband and wife have some issues among them, they need to share it with another party who will try to solve the issues and come down by some conclusion. What is family disputes? Family conflicts refers to the active opposition between family members related kinship, martial, legal ties in different forms: physical, sexual, financial, verbal, and physiological. All families at certain times experience difficulties which can be termed as a family dispute. Such disputes range from a matter such as disputes between husband and wife, relationship breakdowns, child's welfare, financial support for a children, and property settlement. Now, why OPT for ADR? Mainly because of demerits of court proceeding, results in backlog of cases, overburdening of courts, as Corona plays a vital role to define the value of ADR, the word is very uncertain at the moment, and for many people, life has been on hold over the past weeks and months. However, some things have not changed, and relationships, unfortunately, do continue to break down. As a result, difficult family disputes still need to be resolved. A potential solution is a family arbitration. We have been holding family arbitration since they were first introduced in 2012. However, with the COVID 19 crisis, family arbitration has become an even more attractive option than it was before, and we have been able to utilize family arbitration to resolve family disputes even during the height of COVID 19 lockdown. This article will be give you an insight into a family arbitration and help you to understand whether it may be right for you. Does the rule does the Indian law provide for the arbitration in the family matters? Yes, India deals with the arbitration of family matters. Arbiters are preferred more because of the following reason. First, arbitration of divorce for protecting the rights of the divorcing parties. Second, all disputes between parties relating to private rights or obligations. Third, an arbiter can't grant a divorce or amendment. However, he can be only decide to curtain other things. Divorce Divorce arbitration is a process for solving the dispute that have risen between the parties who are divorcing each other. This cannot be done at the sole-based arbiter convention. After hearing from both the parties, the arbiter will come to decision that will be considered and be applied. Provision for the Code of Civil Procedure, Section 89, Settlement of Disputes Outside the Court, Order 32A, Rule number 6, suits relating to the matters concerning the family, alternative dispute resolution, cost and time effective, preserve the relationship between the parties, confusion in manner, encourage the communication and collaboration. Now, I conclude my paper. Conclusion: parties are more comfortable as they can freely express their own views, needs, and interests. The increasing amount of disputes and fight that held among the parties are because of the absence of awareness of alternative resolution techniques. Alternative dispute resolution centers have to create in every area. The Act of Arbitration and Conciliation 1996 helps to resolve disputes by arbitration. Thank you everyone for giving your time. Thank you so much, Garima. Now I want to call Bhanu to present her paper. Namaste to all. I good afternoon, respected Pro-President Sir, Dean Sir, Director Ma'am, guests and the faculty members and all are present here. I, JVN Bhanu, pursuing BLLB 4th year. Today I am going to present my paper on the topic of role of arbitration in family disputes. Introduction is India has very old legal system stretching back of 1000 years ago. India has a legal system since the monarchy. Since time immemorial, the system has changed. India, with a population of 1.3 billion, according to the 2021 census, faces cultural, religious, linguistic, cultural, and ideological diversity, but still has one legal system for all. With all the increasing population, the marriage percentage also increasing, and this will lead to increasing disputes, which all poses a threat to the judges of India who are already heavily burdened. There are about 70,000 cases pending before the Supreme Court and about 44 million in all the courts of India as of January 2021. Justice delayed is justice denied. The phrase implies that if justice is not done immediately, so even later, it would not really fair justice because there was a period of time when there was a lack of justice. If through some alternative options the families get their cases solved in short time, then why they wait for years to get a case to be solved? Here is the history of family disputes and its relation to arbitration. The practice of resolving disputes can be traced back to the days of history when village disputes were resolved between members of a particular relationship or activity or between members of a particular community. In India, in Indian subcontinent, panchayats, meeting of elders and esteemed villagers. These methods of resolving disputes were a well-known way of administering justice and not just an alternative system of justice established by the emperors. It has been
So
observed.
wait for a minute. Tanushi
Yes,
madam, are you there?
yes,
I
sir.
think again the same topic I am seeing here: history of family disputes and its relation to arbitration. The previous two papers back, the same topic was there. So how the presenter will justify the difference? Why so?
Sir, actually, the theme was regarding family disputes, so mostly
Okay,
everybody knows.
okay. But the two papers before the same topic was there: family disputes and its relation to arbitration.
Sir, the theme of the
Anyway,
conference is regarding, yeah.
might be minute difference. Anyways, continue.
It has been observed that the disputes of panchayats and courts have been officially recognized and approved by the awards. The same was noted by the Privy Council in the case of Vetla Sitana versus Marivada Virano. So, the purpose of this research paper is to signify the role and importance of arbitration in family disputes, and the benefits of out-of-court settlements are damages can be recovered faster in comparison of the court proceedings, justice can be achieved in a short span of time with proper proceedings, and third is not so complicated procedure and less expensive and short time consuming method. Here is the how Indian family law system. There Hindus के लिए अलग codified law है, Muslims के लिए अलग codified law है. As like Hindu Succession Act 1956, Guardianship Act 1956, and Maintenance Act 1956, and for Muslims there are Shariat Applications Act and also many other acts. There are constitutional provisions of Article 39A that added by 44th Constitution Amendment. It provides equal justice and free legal aid, and concept of A.D.R. was developed in view of these articles. And also Article 21 of Constitution of India declares that no one shall be arbitrarily deprived of his life and liberty except according to the procedure established by the law. That is without trial by the law. Then there are also statutory provisions. Then I
would like to conclude my research paper at saying that alternative dispute resolution is a blessed to Indian judiciary, and because it reduces burden of cases in courts and provides justice as soon as possible, and that's why the matters dealt out of court are more adjudged reliable than court with proper proceedings and hearing of the case, and the matters can be disposed of soon, are less serious, should be heard outside the court so that it saves the time of the court and party will get justice in short span of time. Thank you.
Thank you, Saloni. Now the next present, sorry, thank you, Bhanu. The next presenter is Garim. Saloni.
तनु नेक्स्ट
तनु नेक्स्ट प्रेजेंटर को बताओ.
नेक्स्ट ऑलरेडी 2:35 नेक्स्ट.
Yes, ma'am. Technical team, kindly remove Nisha because we are not able to join.
Tanushree? Tanushree, am I audible? Tanushree? Am I audible, Tanushree? What happened, Tanushree, ma'am?
Namaste and a very good afternoon all the higher dignitaries. Navdika ma'am Singh ma'am, our pro-president sir and our JD family. I, JVN Apurvi Gupta, pursuing BCom LLB 8th semester, is present before you today to discuss the topic analysis and development of arbitration and other forms of ADR in India. My subtopic being scope of mediation centers and its impact on the ADR mechanism. The concept of ADR was introduced not long ago, but it is a practice since a long time. The development of ADR in India has been a significant one. The settlement of the parties over disputes have been prevailing before even these terms were introduced. The role of private person in panchayats has been a significant one. Moreover, now the Indian government is taking further steps in the evolution of ADR mechanism. Since the increase in the economic development of nations, the number of businesses disputes have also grown parallelly as the competition increases. We all know that our courts are already overloaded with cases, and since the increase in the business disputes, the caseload is increasing simultaneously, resulting in the delay in adjudication. That's why ADR mechanism holds a great importance for the Indian companies. This brings me to the scope of mediation centers. Let me bring myself to the mechanism of mediation. A mediation is a process where the parties appoint a neutral third party to resolve their dispute pre-litigation. The third party being the mediator, who helps to find the solution of the dispute by negotiation from both the parties. The decision and the appointment always stay with the parties. In 1996, a commercial mediation in India was introduced in the Civil Procedure Code under Section 89. The Indian Court encourages mediation very strongly by setting the mediation centers within the court premises and also bears the expenses the centers has. Courts, by the approval of both the parties, refer the cases for settlement by mediation. Since the conventional courts method take years to solve a case and caseload on the court is very high, a lot of cases are pending, making the scope of mediation and in India peaked. So the impact of mediation on ADR mechanism. ADR empowers the Arbitral Tribunal to use mediation as a means of dispute resolution. However, the notion of judicial mediation was first introduced under Section 80 by CPC. The court encourages the parties to settle the dispute outside the court by the method of mediation, arbitration, conciliation, negotiation, etc. But the clause of confidentiality in mediation was always in question. Only recently, in the year 2011, the Supreme Court of India declared that mediation process were confidential in nature, and if the mediation process proceedings becomes unsuccessful, then the statement should be provided to the court by the mediator. It is expected that because of this judgment, the popularity of mediation will increase. Moreover, in the case of demolition of the Babri Masjid, the Chief Justice of India stepped in to facilitate mediation. So mediation has some of the benefits in its process. That's why we should adopt the mediation process. Mediation leaves a positive impact on the society, and the workload of the court is also reduced. So the following traits the mediation process has: it is confidential, as it ensures that the party remains the confidentiality between the party remains. It's voluntary, non-coercive, non-aggressive, sustains good relationship, informal, cost-saving, and control is always in the hands of the party. So I would like to conclude by saying that the alternative dispute resolution mechanism should be adopted fairly by our courts to reduce the caseloads and increase the resolution of the disputes pre-litigation. Thank you so much.
Thank you, Apurvi. Kiran, if you want to present your paper, you can present it, but please take only 3 to 4 minutes because we already have very less time. Kiran, am I audible to you? Miss Kiran? Kiran, kindly present your PPT and please take very less time. Unmute yourself, unmute.
Now, okay. Good morning, sir. Good morning. Good afternoon, ma'am. Role of mediation of consumer dispute resolution. The term mediation can be defined as a voluntary dispute resolution process where the third party facilitates negotiation between the dispute parties to negotiate for their right and interested by themselves. The third party who facilitates the negotiation between the dispute parties is called mediator. Mediator is a neutral person body who helps the parties try to reach a mutually acceptable resolution to the disputes. What is the objective? It is a simple way to resolve the conflict, protect the right of the consumer and provide speedy redressal. Aim to settle the dispute peacefully by way of compromise, negotiation, fair settlement. Mediation is a direct approach to settle the conflict, one-to-one conversation and raises discussion to a better understanding to each party's view. It is a good first step in trying to reach agreement about many kind of problems, dispute between neighbors, separating couples. Mediation is a part of ADR, Untitled Dispute Resolution, refer to a variety of processes that help parties resolve dispute without a trial. Typical ADR include mediation, arbitration, neutral evaluation, and collaborative law. These processes are normally confidential, smooth, less formal, less stressful than traditional court proceeding. The Consumer Protection Act 2019 Act was given assent by the President of India 9 August 2019 and came in force from July 2020. Most of the Act has undergone a drastic change, but some old provisions are also here. The Act Chapter 5th of the Act, which in turn encourages the party to undergo mediation once the complaint has been admitted or at any other later stage, if the member of central authority deems fit and upon prior satisfaction that there exists a scope of the settlement of the dispute, then they may refer the same to mediation and in event of failure of mediation, the complaint shall proceed further. According to the Act 2019, there was a highly need to create new regulation in order to make mediation of consumer disputes more effective. Under these regulations, the National Consumer Dispute Redressal Commission has laid down certain qualification training procedure. Thereon, for the further the implementation of mediator, qualified mediator will have to the mandatory undergo a minimum of 40 hours of training in order to receive the requisite certificate or accreditation. The mediation cell shall maintain a list of in-parliament mediator, a list of cases handled by the cell, recording of proceeding, and any other information may be specified the regulation. Advantage of mediation: completely confidential, less expensive, natural, neutral, safe, resolution-oriented, control the outcome of your future, is voluntary, faster outcome, direct communication, convenient, time-saving, bring parties together. Disadvantage: biased है, no fixed rule, lack of legal protection of the parties,
Miss Kiran, am I audible?
imbalance.
Sorry to interrupt. Actually, we have very much students.
Yes, ma'am.
I want you to just conclude it because we have many more students and we are very less with time. So,
Okay, okay, ma'am.
thank you, ma'am.
Process
Thank you,
of
Miss Kiran.
mediation. Okay, okay, thank you, ma'am.
Now I want to call Saluli to present.
Namaste to all respected dignitaries. I, J.V. Saloni Jain, pursuing BB LLB 4th year, I am going to present my topic on role of arbitration. The world is very uncertain at the moment, and for many people, life has been on hold over the past weeks and months. However, some things have not changed, and relationships, unfortunately, to continue to break down. As a result, difficult family disputes still need to be resolved. However, however, court proceedings are slow, expensive, and stressful at the best time of. So the the resolution of family conflicts requires special procedure, which means that the traditional advisor procedure has to be modified and replaced by the less formal procedure. The approach of the court engaged in the task require a less formal and more active investigational and equational procedure. What is arbitration and family dispute or family arbitration? Arbitration at core, arbitration is a form of dispute resolution. It is a procedure in which dispute is submitted by agreement of the parties to one or more arbitrators who make the binding decision on the dispute which is enforceable by the court. Arbitration primarily entitle parties obtaining for a private out of court settlement. Family dispute all families at certain times experience difficult which can be termed as a family dispute. Such dispute range from matters such as dispute between husband and wife relationship breakdowns, relations, welfare, financial support of or children and property settlement. Advantages of arbitration in family dispute: fairness, confidentiality, timeless, uh, less cost. It is more flexible. Why do it? The outcome of arbitration is a binding decision which will settle the issues in dispute between the parties. However, a judge sitting in a public court can also make such a binding decision. Due to less time, I would conclude my topic. Although not compulsory, giving alternate modes of dispute resolution a chance in the resolution of family matter in the norm of Indian legal system, the practice should actually be given all the support that it can be given. Obtaining the out of court settlement proves beneficial not only the parties but also the general public. The parties are benefited through reduced cost and time lost, while the court are a little less burdened. This allowed for a speedy redress of other suits. So, thank you.
Thank you. Now I want to call Pooja and Priyanka to present them.
Namaste to all higher authorities and Dean Sir, Faculty of Law and Governance. Here we are present PPT on role of arbitration in family dispute. I, GVN Pooja,
And you and Priyanka,
pursuing
reality,
DLLB, fourth year. Arbitration Act 1996. First Arbitration Act 1996 states the object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expenses. The parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. Today, the understanding of the institution of marriage and its importance in society has changed. Marriage is no longer viewed as a lifelong commitment. As the principle of equality had replaced the institution of order as a family law, it provides further reasons for family strife, and it becomes socially acceptable to live marriages that were unbearable or simple unfulfilled. There is uncertainty in humans' life in a modern era, and many people's life has come to standing still in weeks and months. However, some things have not changed, and the relationship, unfortunately, continues to deteriorating. Serious families dispute still there is need to resolve. Pendency of case rising across courts, over 4.5 crore cases pending at present. Between 2010 and 2020, pendency across all courts grew by 2.88% annually. As of September 15, 2021, over 4.5 crore cases were pending across all courts in India. Benefits of arbitration in family disputes. Arbitration builds and involves the opportunity for self-development and social justice, the growth of conflicting group, voluntary goal, and development of the solution by the parties themselves is in line with the expectation of tangible justice. Additionally, mediation promises to reduce cost in a cost-effective and quick way to resolve dispute. Due to less time, we conclude here. In family law dispute, arbitration is a smart, informal approach that often protects the parties' privacy. Mediation is increasingly common in family law cases. The parties can not only resolve disputes through consultation but also receive advice from a mediator who is most familiar with certain situations. It also means that both participants are satisfied as the mediator respond to their views and try to find a consequences that is acceptable to all. Their advice may be second guessing. In addition, if participants are not satisfied with the outcomes of the negotiation, they have the opportunity to go to court. Thank you.
Thank you so much. Now I would like to invite Manisha to present their paper.
उनसे बोल दो
Namaste to all the respected dignitaries. I am Javier Manisha Gupta, pursuing BBA LLB 8th semester. I am here to present my topic on the role of arbitration in family dispute. Let's start. Abstract. India is a secular state wherein large population practices different religion. The Indian legal system over the year has also developed in line with the different religion being practices in India. Let's start introduction. Arbitration is a form of alternative dispute resolution and has traditionally been used in civil and commercial dispute. Arbitrator will look after the evidence, including both the written and oral evidence of a party, and make a final decision. To arbitrator must comply with the IFLs in arbitration rule for the Scheme and Arbitration Act 1996. Benefit of the arbitration. Benefit of arbitration are that it is a quicker, cheaper, and more flexible than court proceeding and provides a binding decision based on family law principle. In particular, may be a very useful where the parties have reached
Manisha, please
agreement but a
come to
resolution
the
is
conclusion part.
remaining they
Manisha,
cannot agree on.
sorry I interrupt you. Manisha.
Characteristics of arbitration process. When parties agree to it, then only this process will work. This process is not partial and fair approach will be made. Parties have the benefit of choosing the arbitrator by mutually deciding. Parties have all the powers of fixing the date, place, and time. Meaning of family. Family is a group defined by sex relationship, subscriber, accurate, and enduring to provide for the procreation and bringing of offspring. Meaning of family dispute. Family conflict refer to active opposition between family causes and complex nature. Family relationship, family dispute can take a wide variety of form, including verbal, physical, sexual, financial, and psychological. Dispute may involve matter like dispute between husband and wife, dispute related children's education, health and welfare, children's behavior, lack of trust, financial support for children in case of separated couple, relationship breakdown, property dispute, money debt. Law related to arbitration, Code of Civil Procedure 1908, Hindu Personal Law and Special Marriage Act also relate this. Family Court Act 1984. The preamble of Family Court Act 1984 enacted by the Indian Parliament lays as follows: enact the establishment of family law courts to promote conservation in secure, fast settlement of dispute regarding marriage and family affairs for matter related therewith. Less judicial pronouncement. In Shiv Kumar Gupta versus Lakshmi Devi Gupta Divisional Bench of Kolkata High Court observed that compliance with this Section 23(2) of the Hindu Marriage Act 1955 is a duty of just trying matrimonial cases. Let's conclude. Conclusion and recommendation. Family is the first and foremost institution. It is the oldest amongst all the institutions where the backbone of society and channelize every other institution of society. And using ADR mercantile is one of the possible solution in 21st century. There is also an urgent need of date to current social system approximately 30 million Indian now live outside India and create efficient legal infrastructure for ADR mercantile in resolving various organized in India, but also which have been separated abroad. And it is recommended by the authors to improve the participation of citizens in ADR mercantile. Without their participation, family arbitration cannot be properly used. The citizen has to begin with restraining themselves using the tradition court litigation. Our constitution gives us the right to speedy trial as not rarely, and fiction the right should be given its due respect. There is an urgent need for the not only establishment of ADR market in urban area but also in rural area. Is process parents and couple need to recognize the advantage of arbitration in family disputes. Thank you.
Thank you, Nisha. Now we have our last presenter, that is Dr. Sarvesh, who is our law faculty. Now he will present your paper, and he is the last presenter.
Namaste to all who are present on the digital platform. Respected chairman, respected um, chief guest and key speaker, respected president and respected uh, dean and director of FLG. Thank you for giving opportunity to present PPT on the topic role of arbitration in matrimonial disputes. India has a old legal system
बस ये लास्ट
and are providing cheap and costless justice. Uh, our Indian Parliament has been passed various legislation uh, for the purpose of to provide justice to the economically disabled person. Basically, arbitration it is a out of court proceeding which provide uh, in short term of justice to the pupil. And ADR, the concept of ADR enshrined in our constitution under Article 39A that incorporated equal justice and free legal aid. Due to short, due to lack of time, I want to finish my PPT. Thank you to giving opportunity.
Thank you, sir. So we have completed our conference on time. Am I audible? Am I audible? Pro President Sir, Director Ma'am, Navtika Ma'am. We have done with all our presenters. Am I audible to you? Veena, we have finished with all the presenters on time.